My Lords, it may be for the convenience of the House if I announce that dinner will be available at the usual time this evening. In view of the length of the speakers list, there will be no adjournment during pleasure.
May I ask the Lord, in view of the number of speakers, would he beg the House not to make long speeches?
Business of the House, Baroness Young.
Lords, I beg to move the motion standing in my name on the order paper.
My Lords, the question is that the motion standing in the name of the noble Baroness Young, be agreed to. As many as are of that opinion will say content. To the contrary, not content. The contents have it.
Second reading of the Canada Bill, Lord Carrington.
My Lords, I beg to move that this bill be read a second time. In December last year, the Senate and the House of Commons of Canada formally requested the enactment by the British Parliament of a bill to bring about an historic change in the Constitution of Canada. And it's this bill which we are debating this afternoon. As one of its central purposes, the Canada Bill provides for the transfer to Canada of the power to amend the Canadian Constitution and the repeal of the power of this Parliament to legislate for Canada. The bill will thus remove the one remaining formal qualification to the independence of that great country which has, in practice, been independent for many decades. And it's instructive to reflect on just how long the Canadians have managed their own affairs. Next week, my Lords, we shall be marking the fact that the Office of Foreign Secretary has been in existence for 200 years, a period which spans the greater part of what most of us think is modern history. And for well over half that time, since the British North America Act of 1867, in fact, Canada has been either self-governing or, in practice, independent, and growing to become what she now is, one of the leading economic powers, a major actor in the councils of the world. My Lords, it is manifestly incongruous that such a state should have to request legislation in the British Parliament in order to change its constitution. But there were good historical reasons for the incongruity. In 1931, the Statute of Westminster annulled the power of the British Parliament to legislate for the Dominions. But there was one important exception to the provision. The Canadians had been unable to agree amongst themselves on a formula for amending their constitution. It was therefore at Canadian request that the power of the British Parliament was retained in relation to the repeal, alteration, or amendment of the British North America Acts. My Lords, as so often in these cases, it was then thought that a satisfactory solution would soon be found to Canada's particular problem. But as we now know, it's taken 50 years to find one. The result of this arrangement was the continuation of the procedure whereby, when the Canadians wished to amend their constitution, a request was made in the form of a solemn address to the monarch from both houses of the Canadian Parliament for the enactment of the required legislation at Westminster. We have enacted 14 amendments to the British North America Act since 1867, not just since 1931, but in all cases since 1886. This has been done at the request and with the consent of the Canadian Parliament. The convention that this Parliament only acts as so requested is enshrined in the third perambular statute paragraph of the Statute of Westminster, which reads as follows: "No law hereafter made by the Parliament of the United Kingdom shall extend to any of the said dominions as part of the law of that dominion, otherwise than at the request and with the consent of that Dominion. My Lords, I turn to the bill which is before the House. Its long title is an act to give effect to a request by the Senate and House of Commons of Canada. The request in question took the form of an address from the Canadian Parliament to Her Majesty the Queen, which was approved on the 2nd of December 1981 in the Canadian House of Commons by a vote of 246 to 24, and on the 8th of December in the Senate by a vote of 59 to 23, and was delivered to Her Majesty on the 9th of December. The first preamble to the bill reflects the terms of the address and makes it clear that everything that follows the first preamble forms part of the Canadian request. That request itself has three elements. First, the amendment of the Canadian Constitution by the provision of a Charter of Rights, and secondly, the conferral of full power on the Canadian Parliament to amend the Constitution under an agreed formula. And both these elements are contained in Schedule B to the bill. The third part of the request is for the termination of the power of the United Kingdom Parliament to legislate for Canada. This is effected by Clause 2. Schedule A, of course, is a translation into French of the measure itself. And the present legislation has come to us in both languages because the Canadian Parliament wished thereby to give full recognition to the official place of the two languages in a request which is so fundamental, because the Constitution Act, which forms Schedule B to the bill, together with the statutes and orders listed in the schedule to the Constitution Act, will form the new Canadian Constitution. And since at least 1867, all acts of the Canadian Federal Parliament have been both in English and French, both languages having been designated under Section 133 of the British North America Act as having equal authority and prescribed for use in the Federal Parliament. My Lords, I would like to comment briefly on the controversial consultations in Canada in the 18 months or so which preceded the approval by the Federal Parliament in December of the resolution seeking legislation here at Westminster. Proposals for constitutional change were first introduced into the Canadian Parliament in October 1980. They were extensively considered in Parliament, and representations from many individuals and organisations were heard. The proposals were at that stage opposed by 8 out of 10 provincial governments. Certain of those provinces referred the matter to the Canadian courts, and an appeal was eventually heard by the Supreme Court of Canada. On the 28th of September last year, the Supreme Court ruled that although there was no legal bar to the federal government proceeding to seek amendment of the Constitution, despite the opposition of the provinces, convention required at least a substantial measure of provincial consent for amendments which would affect provincial rights and the federal-provincial relationships. Further negotiations were held between the federal and provincial governments, leading to the agreement following the First Minister's Conference on the 5th of November last year. That agreement was accepted by all the provinces except Quebec and resulted in the present bill. The Charter of Rights contained in Schedule B to the Canada Bill is the most significant addition to the existing constitutional arrangements enshrined in the British North America Acts. It has been controversial in Canada. It is still contested by Quebec and by some of the Indigenous peoples of Canada. And I would like, if I may, to say a word about each of these things. It is, of course, a matter of regret that the present proposals do not have the unanimous support of the Canadian provinces. But as I've said, the Supreme Court of Canada considered that the consent of all the provinces was not required either by law or by constitutional convention to the making of a request to us. I do not think anyone can reasonably deny that the support of 9 out of 10 provinces constitutes a substantial measure of provincial consent to which the Supreme Court referred. We would all wish that outstanding disagreements could be resolved, but the government believed that this is a matter for the people, the provinces, and the Parliament of Canada to decide. We do not believe that the existence of disagreement provides grounds for declining to act, as we have always acted, upon the request of the Canadian Parliament. Nor do we believe that we would be justified in declining to act on a request of the Federal Parliament because of the further litigation at present in train in Quebec. Somewhat similar considerations apply to the Indigenous populations of Canada. Their existing rights are specifically recognized in the Constitution Act, which forms Schedule B to the bill. But a number of Indian groups have made it known in Canada and in this country that they are dissatisfied with it. They are opposed to the passage of the Canadian proposals through this Parliament without additional safeguards. My Lords, it has been consistently the view of Her Majesty's government in the United Kingdom that any treaty or other obligations concerning Indian interests which still subsist became the responsibility of the Government of Canada with the attainment of independence, at the latest with the Statute of Westminster in 1931, and that it is to the Government of Canada that the Indians must look for solutions to their problems. Nevertheless, as your Lordships know, 3 Indian groups have instituted proceedings in the courts in this country in which they have sought to rely on their ancient treaties with the Crown, claiming that there are obligations of the United Kingdom arising from those treaties which persist to the present day. In the case brought by the Indian Association of Alberta, the Appeal Committee of this House a few days ago rejected a petition for leave to appeal against the earlier decision of the Court of Appeal dismissing the case. The Appeal Committee shared the opinion of the Court of Appeal that any obligations of the Crown to the Indians of Canada were now owed by the Crown in right of Canada and not by the Crown in right of the United Kingdom. In the light of that decision, and of the fact that the other 2 cases are still in the preliminary stages and have yet to be heard by the courts, the government believes we should not delay consideration of this bill. The government consider that the fact that proceedings are pending is no impediment to Parliament's proceeding, if it thinks fit, to discuss and enact legislation, despite the fact that the legislation, if enacted, may determine the outcome of the litigation or render its continuation pointless. There can furthermore, my Lords, be no certainty about when the various legal proceedings will be concluded, and any delay, especially if other actions were then to be initiated, as might be the case, would be indefinite. I do not think, my Lords, I need say any more about the bill or its history. In short, the Canadian Parliament have asked us to enact legislation on their behalf, as we have done on many previous occasions. The government believe that we should respond to this request by passing the bill in the form in which it has been received. Your Lordships will, of course, express your views freely on the bill. It would, however, be inappropriate for the government to do so to the same extent, more especially as the British Parliament is asked to enact in Schedule B legislation which has no application in this country and for which we shall have no responsibility when it has been enacted. In these circumstances, we believe it to be right, it would not be right, for the British government to comment on the substance of Schedule B to the bill, because to do so would rapidly involve us in offering opinions on Canada's internal affairs. Similarly, it would not be right for us to seek to interpret the language of Schedule B, because to do so would inevitably involve, at least to some degree, a commentary on the text. My Lords, the Government therefore commends the passage of the bill, but will refrain from either criticising it or defending its detailed contents. I will make one remark, however, in this connection. I would urge your Lordships to be realistic and not to be over-concerned at the residual controversy surrounding this bill. Canada is a large and diverse federal country in which political authority is not concentrated as it is in the United Kingdom. As I've already indicated, the draft in its present form is the result of a long period of internal consultation in Canada. The resulting package is a compromise. It is not to be expected that such a package would ever be thought ideal by all concerned. But let us not fail to recognise the achievement of the present settlement in recognising the diverse interests involved to the extent which has proved possible. And I should like to take this opportunity to pay a tribute to those who have done this, especially to Mr. Trudeau and the premiers of the Canadian provinces who've succeeded where others have failed in arriving at a large measure of consensus. My Lords, the results of their labours is the draft of a constitution made in Canada for Canadians. This is as it should be. The passage of the legislation will remove a major preoccupation and a source of difficulty from time to time in Anglo-Canadian relations, and this is also as it should be. I need hardly rehearse to your Lordships the scope and depth of the relationships between Britain and Canada. Many of your Lordships, some of whom are to speak in this debate, have made a distinguished contribution to Anglo-Canadian activities and Anglo-Canadian friendship. Everyone will be conscious, as I am, of the common cultural and political heritage of our two countries and of our sistership under the Crown and within the Commonwealth. All will admire, as I do, Canada's dedication to the cause of a more just world and her determination to preserve free society, a determination manifested twice within living memory by her contribution to 2 world wars. And I am confident that the new era, marked by the formal dissolution of a lingering constitutional link, will also be a new era marked by a further extension and strengthening of the less formal cooperation between Canada and Britain. Cooperation in industrial and commercial enterprises, in professional and cultural exchange, and the numerous other activities which go to make up the fabric of modern life. But Lords, I would only just add one more thing. I would express the hope that the noble Lord Stewart of Fulham would not move his resolution. It seems to me, my Lord, that if he really is confident, as he says in his motion, of what the Government of Canada will do, there is no need for him to move that resolution. If he is not confident, I do not believe the motion will either be useful or helpful.
My Lords, the question is that this bill be now read a second time.
Yeah. My Lords, I think we are all indebted to the noble Lord the Foreign Secretary for the clarity, and many noble lords will thank him also for the brevity, considering the nature of the subject, with which he has handled a most complex and at times almost anomalous matter. And it is especially difficult to talk about a constitution where one of the rules of the game, if one may so put it, is one ought not to express any opinion about that constitution. And the noble lord did all this with great skill. For it is the case that the British North America Act 1867 and the Constitution of the Realm of Canada are at present one and the same document. If you want to alter the Constitution, you must alter the Act. And it has, of course, been long understood and established in law and convention that this Parliament would always be prepared to alter if it were requested to do so, and would only alter according to requests and following them. Now, this arrangement seemed good to the parties at the time, and I believe it was, and it has served them well. But quite clear in its nature, it could not be permanent. And the time now has come to do what has been called patriating the Canadian Constitution. But of course it is a more complex exercise than many people would have first thought. A simple declaratory act that this Parliament would never again touch the British North America Act 1867 would have left Canada in the position where she had a written constitution of which there was no legal means of altering it at all. Nor could we simply have handed over to the Canadian Parliament the powers over the British North America Act now possessed by this Parliament. That would have made the Canadian Parliament a body which could alter the constitution of the country. Now, in no federal country is it the case that the central legislature is a sovereign body that can alter the constitution as it pleases. That solution, therefore, would have been thoroughly unwelcome in Canada. It was inevitable, if the constitution was to be patriated, if the device of altering the constitution by means of a British Act of Parliament was to be abandoned, that other means of altering the constitution should be found and agreed on by the Canadians. And the Act, therefore, cannot be simple. It has to set out how this can be done. Then we find that whenever a nation sets to work to draft its constitution, particularly to draft that part which concerns with the amendment of the constitution, it has to look down right to its own roots and to see what are the principles on which this nation is founded. And that is why you find in this Act major statements of constitutional principle on which the whole Canadian approach to government is based. We had never before been asked in this Parliament to make so big an alteration in the Canadian Constitution. All the ones made so far were tiny in comparison. We were obliged, therefore, to look particularly this time to the question, when you say we do this at the request of Canada, what exactly does the word Canada mean? It cannot in fact mean simply the central government and the central legislature. As the Supreme Court of Canada decided, by convention, at any rate, there must be some degree of participation by the constituent provinces of Canada. At one time, it looked as if we should be asked to pass an act from which 8 of the 10 provinces dissented. I think it is quite clear that if that request had come to us, we could not have assented to it. Because although there is no precise definition of how much participation by the provinces ought there to be to make a request from Canada valid, as a matter of plain common sense, a proposition from which 8 of the 10 provinces dissented could not possibly be regarded as an expression of the will of Canada. Conversely, I would agree with what the noble Lord has said. A proposition supported by 9 out of the 10 provinces cannot be regarded as failing to be an expression of the wishes of Canada in this regard, even if it be a province in the exceptional distinction of Quebec. Now, I would conclude, therefore, as far as second reading of the bill is concerned, that we give it a second reading in this House, partly for the compelling reason that it has gone through all the necessary stages in another place, and is not the practice of this House to reject on second reading a bill that fulfills those conditions, but more because the passage of time and the logic of the development of the Commonwealth now make it necessary to pass an act of this kind. I turn therefore now to the motion standing in my name, which I understand it will be proper for me to move formally at a later stage, but which I, and indeed subsequent speakers, may properly discuss now. It is a motion that says that this House is aware of the anxieties that have been expressed about the Canada Bill by representatives of the Aboriginal Peoples of Canada, and is confident that the Government of Canada, in consultation with representatives of the original peoples, will use the provisions of the bill to promote their welfare. The reference in it to consultation with representatives of the Aboriginal peoples is there because one of the provisions of the Constitution is that there shall be a conference in which representatives of those peoples would take part. Now, the noble Lord asked me to consider not pressing this motion and suggested that it was either harmful or it was unnecessary. I think we must look a little more closely at what is involved. It is concerned with this special problem of the position and rights of the Aboriginal peoples of Canada, the Indians, Inuits, Métis, or as they're commonly referred to in this country, the Red Indians, Eskimo, and people of mixed descent. Now, we all know, we've heard a great deal in the last months about the treaties made with many of those Indian other nations and successive British sovereigns from King George III onward. We are now told on the highest legal authority that the responsibility for carrying out any duties we accepted under those treaties now belongs not to the Parliament and Government of the United Kingdom, but to the Parliament and Government of Canada. Well, we can't dispute that legal decision. I'm bound to say a number of laymen will still have this uneasy thought at the back of their mind. A makes an agreement with B and promises that he will do certain things for B. A then makes a further agreement with C and says, my duties towards B are now handed over to C. He will fulfill them. And I do this without any consultation with B, because the Indians were not a party to the emergence of Canada to full independence. At the very least, we must accept that it must be difficult for the Indians themselves, whose forebears made these treaties, to accept the proposition that our obligations to them under those treaties have now been handed over to Canada, despite the fact that Red Indians were never asked whether they wanted that transfer to be made. But there is a larger issue than that. This is a question of the treatment by a great and powerful nation, with people mainly of European stock, their treatment of people of an entirely different race who are a minority and in almost every way, economically, socially, the weakest section of the population. Now, this is, in the world in which we live today, not merely a national, but an international question. We have seen great evils springing from the oppression of minority races, from their being treated with a denial of justice, or what can sometimes be much worse, a lack of imagination and sympathy. We're bound, therefore, to feel a concern for these people. We have said we are confident that the Government of Canada will handle this rightly. Well, it might be argued this is a mere otiose expression. But in a matter where the principle involved is so great and is of such worldwide application, in a matter where, whatever the law, we unquestionably must feel some moral obligation toward the Indians, we ought at least to make some expression of opinion. We cannot, under our Constitution, deny this bill a second reading. We cannot even amend it. But we can, by the procedure of this House, make an expression of view, which I think is exactly what we should do. So that when we hand the bill over to the Canadian government, when their constitution is patriated, there goes with it what is simply a recognition that here is a great problem that affects all mankind, a problem in which we in the past and the Canadians at present have been concerned, and we earnestly wish them well in the solution of it. I do not think really we can do harm by saying that. I doubt if we ought to say less. Let me say a little more about what the treaties confirmed. It is easy enough to smile at what seems to us now the naive language of some of them. That was not how the Indians regarded them. The purpose of these treaties was to safeguard to them their way of life and the necessary amount of land, which was an essential base for keeping their way of life. Their way of life was totally different for many of them. They varied, of course, but for many of them, it was a way of life totally different to anything which we are accustomed. A way of life made up of hunting, fishing, trapping, of handicraft, sometimes requiring great skill and producing objects of great beauty, and in addition, ceremonial, dancing, worship, for the Red Indian does not appear to draw so sharp a distinction between the secular and spiritual sides of life as we do. Now, that way of life required, as I said, a land base if they were to support it. I do not know how many noble lords noticed a passage in the Observer newspaper recently. It was light-hearted, but that did not prevent its being shrewdly relevant to the matter now before us, and moving as well. It described a kind of dialogue of the deaf between white men and red men in a particular part of Canada, where the white men argued that the proper use of a particular piece of land was to put a gas pipeline across it, and this would be of great benefit to everybody in the long run. The Red Indian view was that this piece of land was by nature obviously designed for the hunting of bears. That was what they and their forefathers had used it for a long time, and anyhow it was their land. Now this is just one example. Problems that crop up all the time. They are problems that can be solved. Not easily, but if you call in the aid of politician, administrator, scientist, anthropologist, and above all, if it is treated on the part of the more powerful partner with a desire to do justice, and on the part of the other with a confidence that justice will be done, these complex problems can be solved. We cannot claim, we British, in the time when we had the power to deal with these things ourselves, that we gave them as much attention as they deserved. And it would be wrong, therefore, to make anything we say here a criticism of those who at present hold power in Canada, for they could easily reply by saying, "What did you do about this problem?" But we are now concerned with the immediate present and with the future. What is going to be done in the future? Because so far, the Indians have tended to lose out both ways. The special and spiritual quality of their way of life has often been injured. And if you measure by material standards, degrees of education, employment, health, they compare very unhappily with the white population. I do believe that more recently the pendulum has begun to move in the other direction, that improvements have been apparent. But there has been real anxiety among the Indian communities at this bill, and a fear that its passage might mean that they'd be driven backwards again. What causes that anxiety? First, I think that with increasing technology, the value of a piece of land can be enormously increased if modern technology is applied to it. The temptation, whosever land it may be by treaty right, to get hold of it in order to apply modern technology to it is the greater. Second, a number of the provinces have been particularly concerned in the discussions that led to this bill, discussions in Canada, for provision about the use of material resources. And that has led to a fear that one result of the bill would be a rapid gobbling up of resources now available to the Red Indian people. Next, there is the history of Clause 35 of the bill. Originally, this clause, guaranteeing Indian rights, was in the draft. Then there were consultations between the central government and the provinces, as a result of which it was struck out. It looked as if the striking out of that clause had been the instrument which the central government had bought the adhesion of the provinces. Later on, it was put in again, though with an interesting alteration that we shall want to discuss when we come to committee. Now, I suggest that that handling of that clause can reasonably make Indians feel that they have ground for anxiety. It should be noticed, too, that it is not a clause entrenched, as some clauses are. The Constitution contains the remarkable provision that if any of the provinces of Canada consider that any future alteration in the Constitution doesn't suit them, they can opt out of it. But if the Constitution were altered so as to remove these clauses that protect Indian rights, there is no way in which the Indian peoples can say, well, this doesn't apply to us, we use the power to opt out. They've been given no such power. We must notice also that Canadian governments have from time to time spoken of policies of integration, of fitting the Indian completely into the rest of the population and the disappearance of their own way of life. Now, one could argue possibly that there were solid advantages in doing so, but we have to recognize this is not what a large number of the Indian population want, and it could not be in any way a fulfillment of the treaties or a fulfillment of Clause 35 in this bill to integrate them in that fashion. Now, all these anxieties may well be ill-founded. I merely make the case at present that to entertain them has not been an act of stupidity or foolishness. There is good reason why Indians should be greatly concerned. We want to put forward, therefore, at any rate, a word of reassurance. I know, and I think the noble Lord the Foreign Secretary suggested it, that some people take the view that anything you say about this will cause great offence in Canada. Well, the people of Canada are not all of one mind any more than the people of this country are all of one mind on any topic. I dare say you will find some people in Canada who would consider that any word of comment or criticism on the Constitution from anyone in this House or in another place was an offence to them. But that is certainly not a unanimous view. An important article in the Toronto Globe and Mail, from which I make only one very brief sentence. Commenting on the debate in another place, it said, some of those who spoke to Canada's bill quite rightly urged fairness on the Canadian government. That is to say, they take a quite sensible view. They don't regard their government or any government as infallible, and that comments on a matter like this in the parliament of a friendly country are perfectly reasonable. Indeed, it is well known that members of both houses of the Canadian Parliament speak often very plainly on subjects of human rights the world over, and they are fully entitled to do so. Moreover, apart from other international obligations, both we and Canada are signatories of the International Covenant on Civil and Political Rights. We may reasonably speak to them, therefore, as co-signatories of an international obligation dealing with this kind of problem. But I believe that there is a justification for what we say in this motion that goes beyond any precise legal justification. I have mentioned that this whole matter of the treatment by a more powerful race, the treatment a more powerful race offers or less powerful, has now become a world question, that great evils and dangers follow from the tyrannical use of power. Now, Canada is now going to start a new chapter in her impressive history. We are suggesting, in what we say in this motion, that it would be a very great thing if one of the things she did at the opening of that new chapter was to present to the whole world the example of a great nation which resolved to do justice and to show imagination towards the poorer, the weaker, the people of the other race, and to do that not because they were subject to any constraint, but as a matter of justice and their own honour. I believe they will want to do that. I do not think they will take offence at our expressing the view set out in this motion. It is all we can do. As I've said, we cannot defeat the bill. We do not want to by any means. We cannot amend it. And indeed, although everyone might try his hand at that, it would be foolish for us to try. In legality and constitutionality, then, we cannot do any more than a motion of this kind. But it seems to me that in justice and humanity, we ought not to do less.
My Lords, I should like to begin by thanking the Foreign Secretary for the very clear exposition of the bill itself and what we wish to achieve. And it enables me to be briefer than I would normally have been, although I am usually brief, because I agree entirely with the case which he's made out. Last summer, in the absence overseas of Mr. David Steele, I was approached by the Canadian Foreign Minister, Mr. McQuiggan, on this matter, and he asked me where the Liberal Party stood. And I had no hesitation in telling him that the Canadian government would have the full support of Liberals in the United Kingdom if they asked for the patriation of the Canadian Constitution. And I felt able to give that assurance with some confidence, my Lords, for a number of reasons. First, because I consider that it's inconceivable that a proud and independent member of the Commonwealth should continue to be subject to the legislation of the Parliament of another proud and independent nation of the Commonwealth. And I think the description that this is manifestly incongruous, as the Foreign Secretary said, is absolutely right. Canada has been regarded by all of us, surely, for many generations, to all intents and purposes, to be an independent dominion. Indeed, it's been the view for as long as I can remember that if and when a Canadian government requested the British Parliament to amend the statutes affecting Canada's rights to amend its own constitution, the Parliament of the United Kingdom would comply without demur or hesitation. Mr. Saint Laurent, the Canadian Prime Minister, said in the Canadian Parliament in 1949, and this was quoted by, as he then was, Mr. Philip Noel Baker, and I remember the occasion well. Mr. Saint Laurent said, "It's our responsibility to see that the fundamentals of the Canadian Constitution are protected and preserved. It is a matter, he said, to be settled in Canada by Canadians and for Canadians. It should not be left as a burden on the Parliament of another nation. And I agree entirely with those views of Mr. Saint-Laurent. And that is why, in my view, we cannot possibly involve ourselves constitutionally in matters which must be settled by the provinces and the Canadian government and Parliament working together. My second reason is that I've always believed that when the time arrived to get rid of this anachronism, it would be our duty to accede to a valid request from the Canadian Parliament without negotiation and without amendment. And indeed, I'm advised that this is the case, and that amendments to the bill are inadmissible. We can delay it if we're so minded. I hope we won't. But we cannot insert any amendment if it is not so requested by the Senate and the House of Commons of Canada. Having said that, I know that a number of noble lords are concerned that the rights of Canadian Aboriginal people may not be respected or protected. My lords, I can only say that Canada is a very responsible country. It has a government which has a fine record in human rights, and I have every confidence that the future of these important minorities will be in safe hands. I don't think it's for us to involve ourselves in these matters which are the responsibility of Canadians. That is the point, I think, which was missed by the noble Lord Stewart. Of course the Canadians differ on all these matters. There is no unanimity. But the responsibility for settling it lies in Canada and does not lie in this House. It's 50 years, my lords, next year, since I first set foot on Canadian soil. I had the good fortune to serve with those excellent soldiers of the Canadian Army. I even got a battle dress out of them, and that was a prize in those days. I've travelled the Dominion extensively, from coast to coast. I have many friends there, and I am delighted to support this measure, which I believe is long overdue. And I would like to plead with the noble Lord Stewart, as the Foreign Secretary has done. I'm very puzzled at the reason why the Labour opposition has tabled the motion which appears on the order paper. I hope he won't move it. This matter is a matter for Canadians. I have expressed in clear terms the confidence which I and my colleagues have in the Government of Canada to promote the welfare of the Aboriginal peoples. Why do we have to have a motion repeating that? It seems to me that it's wrong to draw particular attention to this aspect of Canadian affairs above all others affected by the Act of Patriation. I should have thought it was sufficient to pass the bill and express confidence in the Government of Canada. And if it is pressed to a division, we shall be in a difficulty. We simply cannot object to the wording of the motion. But my worry, and I think it's the worry of a lot of people, is that this motion, if we divide on, is going to be misconstrued in Canada as a criticism of the Canadian government and Canadian Parliament. And that is one thing which I hope we shall avoid.
My Lords, it's not my intention to make any comment on the merits of any of the provisions in the Constitution Act 1982, which is Schedule B to the Canada Bill. That is a matter exclusively for the Canadian people, expressed through their governmental institutions, federal and provincial. I propose to restrict myself to matters of constitutional law, and I have 3 points to make. The first is as to the constitutional position of the Aboriginal peoples of Canada, the Indians, the Inuits, and the Métis. I sympathise and share the sympathy which has and understand the motive which has prompted the motion moved by the noble Lord Stewart. There have been, as your lordships are aware, proceedings brought in the English courts on behalf of groups of Indian peoples in Canada, seeking a declaration that the treaty obligations of the Crown towards the Aboriginal inhabitants of Canada are the responsibility of Her Majesty's Government of the United Kingdom. Let me say at once that although the declaration sought referred to treaty obligations, that is a misuse of the word treaty, because they are not treaties in international law, but they have been regarded and treated by the courts in Canada as a source of legal rights and obligations. And if you will turn to clause 35 of the Constitution Act 1982, you will find that what has been judge-made law in regarding these documents as a source of legal rights is by clause 35 enshrined as part of the Constitution. My lords, when the application was made to the courts for the declaration that I have mentioned, the judge to whom it was made in the first instance rejected it both on its merits and upon procedural grounds. When it came to the Court of Appeal, the Court of Appeal dealt with it on its merits, and in 3 carefully reasoned judgments held that the obligations were the responsibility of Her Majesty's Government of Canada, not of Her Majesty's Government of the United Kingdom. While this bill was pending in another place, leave to appeal to the appellate committee of this House was pending, and it was there suggested that the passing of the bill should be delayed until the matter had been decided by this House in its judicial capacity as the Supreme Court of the United Kingdom. The application was heard last Thursday. It does not appear that its result had been reported anywhere in the press, and I think it may be helpful to this House to know exactly what happened. It is normal that applications for leave to appeal should go to what paradoxically is called an appeals committee, which normally consists of 3 law lords. If leave is given, then the appeal is heard by what is called the appellate committee, which will consist of 5 law lords. Because of the constitutional importance of this appeal brought on behalf of the Indian groups, 5 law lords, including the 3 senior law lords, sat on the appeals committee to hear the application. Normally speaking, when we refuse leave to appeal, we give no reasons. We simply say that their lordships do not grant leave in this case. Exceptionally, on this application for leave to appeal, we did give our reasons, and I would like to read them verbatim to this House because they were very short. Their Lordships do not grant leave to appeal in this case. They wish to make it clear that their refusal of leave is not based on any technical or procedural grounds, though it is not to be taken to be their view that there is jurisdiction to entertain an application for judicial review in such a case as this. Their refusal of leave is because, in their opinion, for the cumulative reasons given in the judgment of the Court of Appeal, it simply is not arguable that any obligations of the Crown in respect of the Indian peoples of Canada are still the responsibility of Her Majesty's Government of the United Kingdom. They are the responsibility of Her Majesty's Government of Canada, and it is the Canadian courts and not the English courts that alone have jurisdiction to determine what those obligations are. For the same reason that this House, in its judicial capacity, has no jurisdiction to determine what those obligations are, I should regard it as constitutionally improper for this House, in its legislative capacity, to proffer advice, however tactfully and courteously expressed, to Her Majesty's Government of Canada as to how it should conduct its internal affairs, which have been its responsibility ever since 1867, and which will remain its responsibility under this new Constitution. That brings me to the second point. There is an inter-Commonwealth constitutional convention over the last 50 years that the United Kingdom Parliament legislates for Canada only at its request and consent. The Foreign Secretary has read the preamble in the Statute of Westminster of 1931, which recognises that. It is not open to us to make any amendment. All we can do is to accept or to reject what it is Canada has asked us to pass in the form and in the very words that it has asked us to do so. It would be, in my opinion, permissible to reject if the request from the Canadian Senate and House of Commons was made in circumstances where it was clearly contrary to a constitutional convention of Canada itself. Whether or not it is contrary to such a constitutional convention, it was a question for the Supreme Court of Canada, on which judgment was delivered on the 28th of September of last year. They did hold that there was a constitutional convention, that the request requires a substantial measure of provincial consent. The previous draft constitution was opposed by 8 provinces, including Quebec, and supported by 2. And after the Supreme Court judgment last September, it may well be that United Kingdom Parliament would have been justified in refusing the request of the Federal Parliament to enact a constitution in a form opposed by the great majority of provinces. The result of that judgment of the Supreme Court of Canada was that there was a fresh conference between the federal and all 10 provincial governments, and that was in November. Compromises involving important concessions to the provinces were reached, and the Constitution Act now presented has the approval of 9 out of 10 of the provinces as well as of the federal parliament, Quebec being the sole exception. It clearly meets the requirements of the Constitutional Convention on the point which was decided by the Supreme Court of Canada. And that brings me to the third point. It has been suggested in some quarters that it would be proper to delay the passing of this bill until some new proceedings which have been initiated by Quebec in the Court of Appeal of Quebec have been determined by that court and on further appeal by the Supreme Court of Canada, a matter which would involve months of delay at least. My Lords, I have read with great care the 57-page document which has been lodged in these new proceedings by the government of Quebec and have analysed it. In it, Quebec repeats the claim which was specifically rejected by the Supreme Court in the previous proceedings, that unanimous consent of the provinces was required. At any rate, it says the consent of Quebec is required, even if it is only a minority of 1. The Supreme Court, in the case in which it delivered judgment last September, had before it claims supported by 7 provinces, including Quebec, that there was a constitutional convention that required unanimous support. There was an alternative claim put forward by Saskatchewan that unanimity was not required, but that a substantial measure of provincial support was necessary. What is important is that the court rejected the claim that unanimity of the provinces was required. It accepted the proposition put forward by Saskatchewan that a substantial measure of provincial consent was necessary, and said that it was not for the court to determine how large a preponderance of provincial support was required. That was a matter for the political institutions, federal and financial, and provincial, to decide by consensus. In the result, 10 out of 11 of the governments of Canada, the federal government and 9 of the 10 provincial governments have agreed. If the bill is passed, there is no possibility that the Supreme Court, as has been suggested in another place, would hold or could hold the Constitution Act 1982 ultra vires and void. That too was a question which was specifically decided against Quebec and the provinces by the Supreme Court in its judgment of last September. Quebec's new court proceedings in Canada provide no plausible ground, in my opinion, for any delay in passing this bill.
My Lords, as a Canadian, I am grateful for this opportunity to take part in the debate on the second reading of the Canada Bill. Although I have been a member of your Lordship's House since 1944, I have lived in Canada for all my life until about a year ago. And regrettably, there has been no previous occasion on my visits to this country where I could have taken part appropriately in one of the debates in your Lordship's House. Perhaps in the circumstances, rather than a maiden speech, this might be termed a spinster speech. At any rate, my Lords, I apologize for the long delay in addressing your Lordships for the first time, and I beg your indulgence for this initial effort. For me, as one of the few Canadians who have the honor and privilege of sitting in this House, this is indeed a significant occasion, for, as I hope your Lordships will agree, this bill, if and when enacted by this Parliament, will mark, I think, beginning of a new and, I hope, mutually rewarding relationship between Canada and Britain. As the noble Lord, the Foreign Secretary, in his admirable description of the background to this legislation pointed out, the process by which Canada has sought to acquire complete control of its constitution has been evolving for more than 50 years. In the recent past, some unfortunate statements have been made, often in the heat of emotion, which would have been better left unsaid. But I submit, my Lords, that these unfortunate remarks should not be allowed to affect your Lordship's judgment on the substance of this bill. The fact is, my Lords, that the great majority of Canadians want our Constitution lodged in Canada. Nevertheless, there are some specific provisions of the instrument which are strongly opposed in different parts of Canada for different reasons, and I share some of these legitimate misgivings. These objections concern the rights of Native peoples of Canada, the political and cultural position of the province of Quebec, linguistic and educational rights of minorities, and the eventual application of certain sections of the Charter of Rights, all embodied in the schedules to the bill. Attention has been focused by several noble lords, and generally speaking, on the rights of the Native peoples, the Indians, the Inuit, and the Métis, and whether these rights will be adequately protected under the terms of the bill. My Lords, historically, Canada's record in its dealing with the Native peoples has not been without blemish. Errors have been made in the past. But in comparison to other countries which have been faced with the complex responsibility of safeguarding the rights of minorities, I must assert that Canada's record has been better than most. I would like to cite one or two instances to support this contention. The native peoples, numbering about 1.3 million in Canada, all have the franchise and thus have access to the normal expedients to make their case. Additionally, contrary to some assertions which have been made, the native peoples, through their associations, have engaged in continuing consultations with the federal government at the ministerial and cabinet committee level. In respect to native land claims, the northern people, a royal commission has examined rather carefully these claims and not long ago made strong recommendations in support of the native cause. I would just make one other observation in respect to the recognition of the status of the Indian population, for instance, that the former Lieutenant Governor of my home province of Alberta, the Honorable Ralph Steinhauer, is an Indian. But Lords, although I recognize that all the desires of the native peoples have not yet been satisfied, I believe that the moral imperative of this issue has been suitably impressed upon both the federal and the provincial governments in Canada, and that the machinery will exist under this bill to ensure that consultation will continue, leading to a gradual solution of these problems. The objections relating to language, educational rights, as far as Quebec is concerned, and Quebec's difficulty with joint federal programs and the preservation of the right of veto on constitutional amendments, as has been said by the noble Lord Diplock, to be before the courts of Quebec, and it may be quite a long time before any decision is handed down. In fact, I assume that continued references to the courts could conceivably be made, which would continue for a number of years. Realistically, my lords, since the incumbent government of Quebec is dedicated to the political separation of the province from the Confederation, it is unlikely to agree to any proposal which would perpetuate the continuation of that confederation in its present form. My lords, I recognize and aware that the standing orders of this House provide for all speeches and debates to be made in English. However, Canada is a bilingual country with two official languages, French and English, and this bill before the House is in both of those languages. And I would beg your lordship's indulgence if I just said a few more words in French. Malgré l'attitude déclarée par le gouvernement du Québec, il faut que nous souvenons que le peuple du Québec, dans un plébiscite l'année dernière, a rejeté la proposition de séparation politique. J'espère, comme je pense la grande majorité des Canadiens espèrent aussi, que les Québécois retiennent la même résolution aujourd'hui et qu'ils sont préparés de continuer comme une des nations fondateurs avec la grande entreprise canadienne. Thank you, my lord. It is a matter of regret to me, my lords, as a native of this great province, that a solution has not been found to these objections, and also to the apprehension of the English-speaking minority in Quebec that their language and educational rights are threatened by certain provisions of the bill. There are other dangers embodied in the Charter of Rights, such as in Section 33, which could be interpreted as circumscribing some of the fundamental rights of all Canadian citizens. But, my lords, the door will not be slammed by the enactment of this bill. The process of constitutional development will continue, but it will continue, as I submit it rightfully should, not here in Westminster, but in Canada. In short, my lords, this bill is a result of a compromise. Some might say a characteristically Canadian compromise. But I submit that no compromise solution to any problem can ever be entirely satisfactory to all sides. Casting a shadow over the whole future of the Canadian Confederation is the concept that has come to be called separatism. It is, as I have said, a declared policy of the present government of Quebec. But it is also manifest in Western Canada, where a feeling of alienation has been growing in recent years. It would be presumptuous of me to ascribe any blame for this development. However, we in Canada will have to find a solution if our country is to develop and prosper as it rightly should. May I reiterate that this bill does not satisfy all the aspirations of all Canadians. But, my lords, in political terms, we are the masters of our fate and the captains of our souls. And the resolution of our differences must be made in Canada. I therefore commend this bill to your lordship's approval.
My lords, it is to me a great pleasure and a privilege to follow the noble Lord Shaughnessy in his maiden speech. And if I may be permitted to say so, it was a delight to hear a Canadian voice dealing with a Canadian bill. The content of his speech was of considerable interest to all of us. I especially like the way in which he was absolutely impartial in its introduction. And I'm sure all noble lords in this House will look forward with great interest to hearing him again on many occasions. My lords, whatever the reason, it does seem to be somewhat of an anachronism that after many, many years of the formal independence of Canada, that we should be concerning ourselves with a bill to patriate the Canadian Constitution. And there is not much more we can do with it than that, but to send it back home. The Statute of Westminster made it absolutely clear that the Canadian Constitution could only be patriated, or any amendment made to it, at the request of and with the consent of both houses of the Canadian Parliament. As has been said, under the 1931 Act, we cannot amend it or alter it in any way, even if we should wish to do so. I suppose we could, if we so wished, reject the bill. But I'm quite sure that no one in this House, and I hope no one in the other place, had any intention of doing that. We are entitled to ask, I think, my Lords, why has this step taken so long? It certainly wasn't the fault or the desire of the successive British governments to withhold patriation over the years, but the truth would appear to lie in the fact that the federal government of Canada and the provincial governments have found it difficult to agree amongst themselves. We now know at long last that only one of the provincial governments stands outside. We know, too, under the ruling of the Supreme Court of Canada, that an absolute unanimous decision was not necessary, so we can, in fact, proceed. It would have been very pleasing if this bill had been presented to us with the unanimous approval of the federal government and all of the provincials, but it hasn't. And we have to take the position as it is. It would have been equally pleasing if there were no outstanding constitutional cases before the courts either in this country or in Canada. But again, that is not so. However, I understand that this sort of bill is not subject to the normal sub judice rules. One can understand the reason why that is so, because in fact, anyone who wished to delay the bill could go on perpetuating court cases either here or in Canada ad infinitum. I'm indeed sorry that Quebec is standing outside, because something like, we are told, 40% of the legislature in Quebec felt that something could be done in favour of patriation, if not, in fact, completely in line with this bill. My Lords, those of us who have read the debates in another place and have received the not inconsiderable amount of literature which has been availed to us have been profoundly interested in the case presented to us by the Aboriginal peoples. And I cannot help myself but feel that what worries them in the main is mainly the fear of what is likely to happen after, and not now, but after the Canadian Constitution has been patriated. They do feel, they do worry that their treaties and their rights may be eroded. And let's be perfectly fair, as the noble Lord Shaughnessy was. Certain things have been said in high places in the federal parliament that could have given grounds to some of those fears. Before us, my lords, we have a bill, and in the sections 25 and 35 of the Schedule B, there do, to my view, seem to be adequate protection for the rights of the Indian peoples. Again, under Part 4 of that schedule, a new constitutional conference is to be called in 12 months' time after the passage of the bill, attended and consisting of the Prime Minister of Canada and the First Ministers of the provincial governments. This in itself should be reassuring to the Indians, but I'm afraid that it may add to their worries. I hope, therefore, at that stage, in 12 months' time, that the Indians will be fully consulted and not as just mere observers. I would like myself to see more responsibility for the indigenous people, for the Indians, resting with the provincial governments, as well, of course, as the federal government. I say this because we understand that more than 60% of the Canadians feel that the lot of the Indians could be materially improved. My Lords, from my own experience of working with Canadians, a very short experience, the 1966 Prime Minister's Conference had to deal with the problem of Rhodesia and Mr. Smith. And in that conference, the late Mr. Lester Pearson proved himself to be very, very concerned about the indigenous peoples with whom we were dealing during those debates. The African Commonwealth colleagues at that time were highly critical of the United Kingdom government for their handling of the Rhodesian affair. But the Canadians were particularly helpful, and I felt, it was my impression, that they had an understanding of what was required in that part of Africa to get what we have got now, a solution to the problem. Whilst the Canadians stood absolutely firm, I regret to have to say that the Australian and New Zealand colleagues were more or less standing on the touchline. I cannot believe that any Canadian government today would behave any less well in matters of human rights than they did in those days. In consultation with the representatives of the Indians who were over here, in reply to a direct question, I was told we ask for nothing more than that our existing treaty rights on land, hunting, fishing, trapping should be entrenched in a future Canadian constitution. I don't regard this as a great deal to ask, and I'm quite sure that the Canadian government will have this in mind in 12 months' time when they're discussing Part 4 of the bill that's now in front of us. One very endearing characteristic of the Indian is their profound respect and belief in the Crown. Some hundreds or more years ago, almost 200 years in fact, they referred to our Queen of those days as the Great Mother across the water. And they felt that all of their applications at this stage were addressed to the Crown and not to the government. I'm sure it helps them in their problems and worries to realise that Her Majesty today is also the Queen of Canada. My Lords, I suppose that we would have preferred not to be involved in the constitution of an independent Commonwealth country. But we are involved, and on this bench we feel that the best service we can give to all of our Canadian cousins is to get on with the bill and to get it on the statute book. I was interested and liked the motion on the order paper in the name of Lord Stewart of Fulham. The fact that it has been tabled, I don't think it does any harm at all. And if I may remind the House, it simply says, is confident that the Government of Canada, in consultation with the representatives of the Aboriginal peoples, will use the provisions of the bill to promote their welfare. I'm sure that is all of our wish. But equally, I hope that the official opposition will not take this motion to a division, will leave it where it is on the order paper, withdraw it at the end of the day. Because if a division takes place, I'm afraid we cannot support them from this bench.
My Lords, may I first of all add my congratulations to the noble Lord Shaughnessy for his outstanding speech and for his manifest fairness in presenting his evidence to us. I was additionally grateful to him for the passage of French, which almost persuaded me that I had ability in that language. And may I also make my apology to the House and to the noble Lord, the Foreign Secretary, that I shall have to withdraw before the end of the debate. It is a long list of speakers, and most of them seem to adopt a system of brevity, which I hope I shall be able to emulate. But any brevity should not, I think, reflect a lack of concern on my part and upon those who occupy these benches when we consider the evidence which has been put to us in various kinds of ways concerning the situation of the Aboriginal peoples in Canada. We are deeply concerned for them, and I realise the whole House is concerned for them. I have no skill to present constitutional or intricate legal matters. It is this desire that we have that everything possible should be done in order that this bill may pass through quickly and in order that some of our doubts may be satisfied. May I explain one or two of these doubts? There is some evidence, and it has been mentioned in the House already, that the Canadian federal and provincial governments might wish to diminish rather than continue native titles to their lands in Canada. This is a serious accusation, and I can bring no evidence to support it, but it's an accusation that has been made, and it's one that one wishes could be disposed of immediately by those who can do so. We are naturally concerned, all of us, to see that everything is done constitutionally to preserve the rights of all the peoples of Canada, and these people in particular, who seem, or have seemed, by what we've heard already, to have been at some risk. My attention has been drawn to the opinion of Professor James Fawcett, 3 times President of the European Commission on Human Rights, who says that we have an obligation to give them protection under the International Convention on Civil and Political Rights. And I wonder what the government would say to that. We've heard about the case from several people already concerning the appeal before the Quebec court, and I must say I'm overawed by the noble Lord Diplock's contribution on this, and I think I'd better pass it over. There are also the 3 cases in the courts of this country, which the noble Lord the Foreign Secretary tells us do not really stand in the way. I gather also that the Canadian Parliament's debate on the Constitution was guillotined before some of its most crucial sections could be discussed. These include Section 48, which eliminates the discretionary powers of the Queen's Governor-General in Canada. That, I'm sure I should be told, is a matter for the Canadian government and not for ours. Lord Denning, in his judgment in the Court of Appeal, stated that in 1930, by the British North American Act, the United Kingdom Parliament gave the force of law to agreements which had been made between 1876 and 1929 with Indian people. He says, that act seems to me to recognise that the Crown had subsisting obligations to the Indians under the treaties. That is why it was necessary to have the agreement confirmed by the Parliament of the United Kingdom with the assent of the Queen. This certainly does not appear to accord with the policy taken by the government, that in fact all residual fiduciary rights have been passed over to the Canadian government in practice over many years, and that is to be the position now. Lord Denning goes on to say that now that the Crown is separate and divisible, he thinks that the obligations under the proclamation over treaties are obligations of the Crown in respect of Canada. He therefore sees the present bill as enabling these obligations to be embodied in the new Constitution, which therefore includes Clause 25, which he judges to guarantee the Aboriginal people its rights and freedoms, which he discussed earlier. And this, of course, we all of us welcome very much indeed. There are, however, 2 further points. First, in Clause 35, Part 1, the word existing freedoms, rights and freedoms is used. And the history of the way in which this word came to be inserted when Clause 25 was restored as a condition of gaining federal support for the bill leads me to have grave doubts as to the way in which it might be used to exclude future rights. Are we to stand by the existing rights of that time, which of course in changed circumstances could be a diminution? Secondly, there is no requirement that the Indians themselves should be party to the Constitutional Conference, and failure to consult them so far gives no warrant for assuming that they would be consulted in the future. Nevertheless, as regards the judgment of Lord Denning, I am aware that the Master of the Rolls with his colleagues dismissed the appeal. I asked them 3 short questions. The first is concerning the Quebec Court of Appeal, which I have already mentioned. The second asked, what is the position if the cases before the courts in this country rule in favour of the Indians? And why can we not wait just a little time in order to see how this litigation emerges? And lastly, even if the legal position be such as the government asserts, why does not Parliament have an overriding concern under the International Covenant on Civil and Political Rights to assure itself that the legislation will not put us in breach of our obligations under this covenant? I am aware, of course, that when this has passed and patriation has taken place, the Aboriginal peoples of Canada, as in other places, will have rights with the United Nations and the international courts. None of us, and certainly none of us on these benches, wishes to oppose the return of full legislative powers to Canada. We just wish to be assured that our international obligations have been met and that we have done all that is within our powers to ensure that the protection given by the Crown to the Indians by the courts is safeguarded for them.
Lords, I would like to add my congratulations to those who have been given to the noble Lord, Lord Shaughnessy, for his admirable speech that he made to us today. I don't know if he realizes how refreshing it is to hear one of Her Majesty's subjects from Canada coming and speaking to us in this House. Incidentally, my lords, the only French I remember hearing in both Houses of Parliament, either House of Parliament here, is le roi, le veut. And this is the only precedent which he set, which I hope will not be too infectious. Lords, perhaps I ought to declare a personal interest in this matter we're debating. It was my great-great-grandfather, Lord Durham, who wrote the Durham Report, which in fact set up the first constitution for Canada. So this is to some extent for me unfinished business. It is of interest perhaps to recall that he used to speak of Britain's protected territories as a process of graduation from dependence to independence to interdependence. Not a bad forecast for 1836. He was also concerned primarily with the unity of Canada as a country. And that too, today, is our concern, that Canada, with all its authority, should be able to speak as one nation in the councils of the modern world. In the 1950s, late 1950s, when I was at the Commonwealth office as Commonwealth Secretary, patriation was occasionally mooted, and I had to study the matter as best I could. And I remember that I took the very definite view that following the North America Act and the Statute of Westminster, that the Canadian Parliament and the Parliament at Westminster were equal in status, and that therefore, should a request for patriation be made with the authority of the Canadian Parliament and the measurable support from the provinces, that the correct response for the British Parliament was to grant that request. And I remember that point of view being supported on a number of occasions by the late Lord Jowett, for whose judgment on constitutional matters I had a great respect. And again, we've heard the Noble Lord Diplock today on the constitutional and legal issues, and so I need not add to that. I'm more concerned with the politics of the matter. Lords, the fact of the matter is, it seems to me, that after so many years of absence, point made by my noble friend the Foreign Secretary, from participation in Canada's internal affairs, the British Parliament is in no position to judge the appropriate or even the desirable relationship between the provinces of Canada and the federal government of Canada. Plainly, the future constitutional development of Canada must be settled from now on in Canada, by Canadians, for Canadians. That is the only possible future that we can foresee. The same kind of considerations, my lords, I would think govern the relationship between the British Parliament and the Canadian Indians. The tribes and the communities are scattered all over Canada, and we could not conceivably, from Westminster, judge their interests in relationship to the province in which they may live, or in relationship to the federal government. And we could no longer protect the interests of the Indians, and it is really kinder in this day to say so. I happened to be in the Canadian Parliament at the time of the great debate on the gas pipeline, and incidentally saw one of the most successful filibusters I ever saw, heard in that debate, when a Canadian Member of Parliament read through 3/4 of a newspaper before the Speaker pulled him up and said that he thought he perhaps get a little nearer the subject. Upon which the Honourable Member said, "Well, Mr. Speaker, if you will help me to identify which passages in this newspaper are really nearer the subject, I will be grateful." And he read through the paper again, and his speech took 5.5 hours. But, my lords, now in these days, of course, we could have no influence on any such question in Canada, and it is better that the Canadians should take over these matters entirely for themselves. And, my lords, on the amendment, or the words written by, put down on the paper by the Noble Lord Stewart of Fulham, I can see no reason to suppose that the elected representatives of the people of Canada will not honour the trusteeship towards the Indians of Canada just as well as we have in the past. Now, I quite understand the thinking behind the words he's put on the paper, but, my lords, we must really not try to tell the Canadians what they should do about their internal affairs. It is a temptation to which we must not yield. And therefore, I do hope that he will take the sense of the House, which I think is something pretty near that, and while leaving his amendment on the paper, that he will not press it to a division, which I think would be a blemish on what would otherwise, I hope, be a very constructive and helpful debate. Lords, happily this bill comes here in much more favourable circumstances than was the case 18 months ago. As has been said, all the provinces, with the exception of Quebec, are now agreed on the constitutional shape of things to come. And therefore, my lords, I hope that all stages will very swiftly follow the second reading of this bill, so that Canada can set out in high hopes on a new era of prosperity.
My Lords, when I decided some months ago to take part in this debate, there were storm clouds gathering and a deep depression was developing on the other side of the Atlantic. And I must admit that some of that depression rubbed off on me. it seemed that whatever route we took, we were bound to cause considerable animosity amongst an important element of the Canadian people. If we followed the wishes of Mr. Trudeau and his friends, we would alienate 8 of the provincial premiers and a large proportion of the population of those provinces. However, if we heeded their wishes, we would beg your pardon. If we heeded them and rejected the federal government's request, we would be accused of interfering in Canadian domestic affairs. In fact, I'm sure it was as evident to your lordships as it was to myself that the only sure result was that our friendship and goodwill with Canada would come under severe strain and perhaps even be irrevocably damaged. A friendship which until now had stood the test of 2 world wars and many other lesser strains, and one which many of us remember had the instant support in our time of need in 1940. I had the privilege of coming over with one of the Canadian Army divisions, and I well remember the enthusiasm and eagerness with which those young men set sail to come to the aid of the mother country. And Britain still was the mother country in those days. Additionally, admittedly, when we arrived, some people did find it advisable to take in their daughters out of harm's way, or perhaps it was out of temptation's way. But anyone who has had the Canadians alongside them, when the chips are down and battle is joined, will, I'm sure, agree that it is very reassuring to have them on your side. But that is the past, and today Canada is more than ever a steadying influence in the world, and one which we should never underrate or take for granted. My Lord, sometimes I have an uneasy feeling that we in Britain have a tendency to assume that special relationship with Canada. Certainly there is an understanding, but today it is based very much more on mutual respect between equals. And it is therefore more than ever necessary to work hard to maintain that goodwill and friendship. Much has been written and spoken of the legal and constitutional issues of this bill, and I freely admit that I am no way qualified to express an opinion on those aspects. However, there is one ruling of the Canadian Supreme Court which I found particularly significant, and that is where they state that conventionally a substantial degree of provincial support is required for any constitutional change put forward by the federal government. In my opinion, this was and is still vitally important, particularly in a federal state such as Canada. But there is no doubt that initially this support from the majority of the provinces did not exist. In fact, in Alberta, anxiety and concern ran so high that there was even talk of separation from the rest of Canada. And if that wasn't the case, then there was talk of forming a Western Provincial Alliance. When one considers that Alberta has 80% of Canada's oil, enormous reserves of natural gas, and some 500 years' reserves of coal, this is perhaps not altogether surprising, particularly as under the original bill, she stood to lose much more than any of the other provinces. At that time, like many of your lordships, I received a large number of letters, literally begging me to do whatever I could to stop the proposed legislation. It was a very emotional issue with the Albertans, and many of them, knowing that I was born out there, I'm also a fellow Albertan, turned to me, hoping for some reassurance. Happily, however, these storm clouds have now dispersed, and reason has prevailed. Some of the credit must be attributed to the level-headedness and tenacity of the provincial premiers. But as much, if not more, must surely go to the Select Committee here at Westminster, who produced such well-reasoned and balanced findings. And their conclusions, I know, were warmly welcomed by the people in Canada. I believe this went a long way to convincing the Canadian federal government of the strong feelings held here in Britain, thus contributing materially to the eventual satisfactory outcome. And I would dare to hope, therefore, that your lordships will feel able to indicate your support, thus ensuring that an equally satisfactory outcome here in Britain. It is regrettable, certainly, that Quebec found it impossible to add its signature to those of the other provinces. But it should not be overlooked that the Liberals in that province, who hold 46% of the votes, did in fact indicate their agreement. Then again, there are those minority groups, in particular the Indians, of which we have recently just heard quite a lot, who do still have some objections. But it is my understanding that they are as fully safeguarded under the proposed new constitution as previously. And additionally, there is, I believe, an undertaking to hold a conference within a year of the passing of this bill to consider all matters concerning those minorities. My Lords, my chief concern has been the threat to our good relationship with one of our oldest and most faithful allies. I believe we have a clear mandate from the people of Canada. They have indicated their wishes. May I therefore, in all humility, urge your lordships to give this bill your total support, thereby confirming your confidence in the good sense of the Canadian people and of their Parliament.
My Lord, it is my privilege to be the first to congratulate the noble Speaker who has just resumed his seat on his maiden voyage, and especially, if I may say so, to congratulate him on two elements which were contained in that most felicitous speech of his. First, the enduring amity between people in this country and the people of Canada, and secondly, the very large measure of agreement that apparently seemed a few years ago to be beyond the possibility of the provinces, which has now almost produced unanimity, but not quite. I hope that we shall hear the noble Speaker again, and we shall profit as much, I'm sure, next time as we have on this occasion. I will assume that the speech made by the noble Lord the Foreign Secretary and the speech made by my noble friend, Lord Stewart, have presented an unanswerable case that this bill should go forward. I will also assume that it is within the province, and certainly a part of the duty of this House, to make such comments as we believe may be instrumental in making this bill not only legally effective, but morally applicable, and may be the bellwether of future legislation which will improve upon it, as legislation quite often has a habit of doing. I wanted a very brief speech to say something about the Indian problem, and to confess that initially I knew very little about it. My knowledge of the Indians was largely confined to tomahawks and feathers, until I went to the museum in Ottawa and found that the tomahawk was originally a domestic mallet, and the feathers had very largely been provided by Buffalo Bill, and the motion picture industry. What I have discovered, I find nothing short of appalling. And I will venture to categorize some of those things which belong to the real facts about this minority, this Aboriginal minority in Canada. They have a life expectancy 10 years less than those of other Canadians. Canadian Indians experience violent deaths at more than 3 times the national average. Suicide has increased by over 60% among Indians and by 85% by young Indians, males between the ages of 17 and 30. Infant mortality is 4 times that of the other Canadian citizens. 60% of Canadian Indians receive social assistance and only 32% of them are employed. 60% of Indian homes are not properly serviced. And so one might go on. And I ask myself, what explains this deplorable catalogue of comparative and indeed in some cases absolute misery? And I venture to ask your lordships to entertain the belief that it has a lot to do, if not primarily, to do with the actual spiritual condition, so-called, of this group. They have been the victims of spiritual, or should we say, religious imperialism. They have been regarded as suitable for assimilation into cultures which were foreign to them, and consequent upon the destruction of the cultures to which they were habituated. Many of those cultures can come under moral criticism, but they nevertheless instituted a kind of discipline which, when they were destroyed, did not give place to a comparable discipline from the so-called Christian churches. And I stand as one who must accept a very considerable amount of blame for the persistence in the 19th century missionary enthusiasm, which in so many respects denied the virtues of primitive cultures and believed that outside the Christian faith, as some of our hymns said, was nothing better than total darkness. This is a monstrous piece of impudence and has resulted in all kinds of calamities, not only in America, not only in Canada, but in Australia, not so much in New Zealand, and certainly among the detribalized black groups in southern Africa. Now, this is the point at which I believe the various perturbations and fears of these Indians has to be set. First of all, on the question of assimilation, when Mr. Trudeau categorically asserts that assimilation and integration is the purpose of this particular act, or this particular program of the present government in Canada. I do not believe in assimilation or integration as necessarily the ways in which you improve the condition of those, in some cases, whose cultural levels are not so much lower than ours. And in any case, I believe that we should proceed with great caution to try to make people of such different cultures into, in many respects, it seems to me, nothing more than caricatures of the prevailing civilization, if we are pleased so to call it, that is the dominant one in the North Hemisphere Christian procedure and program and life. Secondly, on the question of land, it is for an Indian, so I'm given to understand, not a matter merely of propriety or property. It is a matter of deep religious conviction. And we oughtn't to be surprised at that when we reflect that the fifth commandment promises those who honor their father and mother to live long in the land which the Lord their God has given to them. The Indian believes most faithfully that the land belongs to the gift of God, and in his case it's rather, I think, less dubious than the behavior of the ancient Israelites in grabbing somebody else's land in Canaan and saying that God meant them to have it. However, be that as it may, I won't go into that in any detail, merely to make the very, it seems to me, very pertinent comment that you do not destroy the beliefs that people have by merely rearranging the economic conditions in which they live. And unless we can take the question, unless the Canadians can take the question of what land means to an Indian much more seriously than they have in the past, I do not believe that this dreadful catalogue of misery will be very much improved. The same, of course, is true of existing rights. The noble Lord Diplock did not mention that Clause 34 became Clause 35 when the insertion of the word existing was interpolated, and the existing rights closed the door to the improvement of what seem to me in many respects to be very imperfect so-called rights that hitherto have existed. My time is also up, almost up. I believe that it is true to say that very largely the attitude of frequent administrations in Canada has not with malevolent intention, but has in principle perpetuated the evil of the missionary enthusiasm, not so much for the promulgation of the Christian faith as for the institutions which have persuaded some people that the kingdom of God and the British Empire were more or less synonymous. May I therefore finish with one comment that seems to me equally pertinent. These Indians, so much as I have had repeated acquaintances with them over the last few months, and when they're not very taciturn, they do take the view that this is a spiritually energized house. They regard the House of Lords in very much the same way as they regard their own conference of elders. And therefore, I would submit to your lordships that they will take a great deal of care and pay a great deal of attention, almost reverent attention, to what this House happens to say. And I would plead with your lordships that we do offer to the Canadian government not only criticism, which after all is cheap and easy, but nevertheless we offer to them a constructive contemplation of some of the underlying problems with which they are confronted, and in particular those which face them with regard to this minority we call the Indians. I believe they have their own right to their own life within a multiracial society, and this should be the aim and intention of the government to which we patriate the Constitution.
My Lord, as one of only 3 members of your Lordship's House who've had the honour of serving as British High Commissioner in Canada, the others being the late Lord Amery and the present High Commissioner, Lord Moran, I'm happy to be associated in this debate, and particularly to pay my tribute to the 2 Canadian maiden speakers, Lord Shaughnessy and Lord Rodney. My Lords, the remarkable thing, I think, about the Anglo-Canadian relationship is that it's been characterised by such friendliness and warmth, as the noble Lord Rodney was saying, despite the extraordinary arrangement the 2 countries made together 115 years ago, when they devised a constitution under which Canada was made self-governing and later sovereign and independent, but that was limited because her constitution could only be amended by the parliament of another country. Surely that's almost a unique arrangement in the world, and it says much for the tolerance and understanding between the 2 countries that there's been so little friction as a result. We're now asked to bring it to an end. My Lords, there's no problem at all about, as it's called, patriating the Canadian Constitution. There never has been any difficulty. Some years ago, I was involved in making informal representations to the Canadian government, and it may be pertinent to recall very briefly what was said then. We pointed out it seems unreasonable that the sole means of amending the Canadian Constitution should be by way of the United Kingdom Parliament, since it's clear that it cannot effectively discuss the merits of the case. And we went on to urge that the present practice has become increasingly anomalous and likely to lead to friction, and we felt that Canada would want to consider what methods of amending the Canadian Constitution in Canada could be made in future. My Lord, that memorandum was submitted in the year 1943, nearly 39 years ago, and I feel some of it is still relevant today. So there's no problem about patriation. The complications come because the resolution before us not only patriates the Constitution and also provides, as is necessary, a procedure for amendment, but it forwards the Canadian Charter of Rights and Freedoms, provisions for the rights of Aboriginal peoples, for equalisation and regional disparities, and arrangements for a constitutional conference. One understands the need for all this because of the federal dimension in Canada, but the provisions do cover an alarmingly wide front in a most all-embracing way. But they all are matters for Canadians, and they're not matters in which we can properly be involved because we have neither knowledge, as the noble Lord Hugh Herschel was pointing out, nor authority. And in my view, in an ideal world, it would have been far better if these very complicated provisions could have been left to be worked out by Canadians in Canada. But as it is, the British Parliament could not be expected, I think, to enact such important provisions without due deliberation. And on this, as we were reminded earlier, doubts were at one time expressed about the role of Parliament here by Canadian ministers 18 months to 2 years ago, with the suggestion that Westminster was under an obligation to accept automatically any request coming from the Parliament in Ottawa and to act upon it. Well, I'm bound to say, if this view had been pressed at the time, in the circumstances of 18 months or 2 years ago, when 8 of the 10 provinces were objecting, many of us, I think, would have been placed in a position of very considerable difficulty. But fortunately, there's really no need to go any further into that past history, because we're all clearer about the matter now, thanks partly to the admirable series of reports from the Select Committee on Foreign Affairs in another place, and of course by the authoritative judgment of the Supreme Court in Canada. In any case, thereafter, the scenario was changed by further negotiations between the federal and provincial governments, with the result that, as we know, 9 out of the 10 provinces are now supporting the proposed changes. Now, it is, I think, profoundly unfortunate that the one province outstanding should be Quebec, a founder member of the Canadian nation and the symbol of French-speaking Canada. And we here cannot tell what the consequences of this apparent division may be. But, again, my lords, this is a political problem for Canada. It's one for Canada and not for Britain. And as far as we're concerned, I think we can only express the hope that Canadians will indeed find their own solution to their own national problems. But I have no doubt that Quebec cannot impose a veto, and there's no cause on that account to decline to act on the request that is before us. My lords, there are just 2 other matters that have been touched on as reasons for not agreeing to accept the bill at this stage. The first is that, as litigation is pending both in Canada and in this country, we should suspend action until matters have been finalised. Well, I'm sure we were all impressed by the very authoritative view of the noble Lord Diplock on those points. And frankly, I think one is bound to accept the point that once litigation begins, there may be no end to it, and unless we act now, we might defer matters for a very long time. The second matter, to which a great deal of attention has been paid both here and in another place, is, of course, the question of the Indians. Because Indian rights are specifically included in the Constitution Act before us, it's inevitable that the matter should be raised in Parliament here. But I'm bound to say that my own view is quite clear that this is really solely a matter for Canada, has been for at least 50 years and probably longer. And I'm afraid I must say that I think it was a cruel deception often on the Indian peoples to suggest that matters were otherwise, because I don't think there was ever any possibility that the British government or Parliament could, should, or would act in these matters. I have to remind your lordships that Britain has given independence to a very large number of colonies and other dependent territories. I've been racking my brains to think if any single one of them would ever attained independence without having a minority problem. And I don't think there is one. There are minorities in all countries. And I think it's out of perspective to suggest that the British Parliament can do in Canada what, as far as I can recall, has never been suggested that we should be asked to do for the Maoris in New Zealand, the Aborigines in Australia, or for that matter, any of the African peoples in what is now the Republic of South Africa, all of whom were, of course, at one time under our jurisdiction. And therefore, I was impressed by what the noble Lord Stewart said, the very moderate and persuasive way in which he put his case. At the same time, I'm unhappy about it, because I do think there's a danger of two implications being read into the resolution, certainly if it were to be voted on and passed. The first, that there is a responsibility still resting on the British Parliament in this matter. Now, I know the noble Lord Stewart referred to moral responsibility, but I think if a resolution, if that motion were adopted, wider inferences might be drawn. And the second point is that I do seriously think that there is a danger of it being regarded as an interference in the domestic matters of Canada, a matter on which we've really been so scrupulously careful always in the past. And I would therefore join with others in hoping that the motion would not be pressed when the time comes. My lords, whatever concerns we may have, and several noble lords have voiced them, and I've mentioned some of them that trouble me, I'm quite satisfied that the resolution of the Canadian Parliament is entirely proper, in conformity with convention and constitutional proprieties, and that we should pass the bill. My lords, let us complete this business with dignity and dispatch, and in ending this remaining formal link, let us send to Canada an expression of our admiration for their achievements in the past, of our continuing friendship for them today, and our hopes for their greatness as a nation in the future.
My lords, I would like, if I may, to join with the other noble lords who have spoken in congratulating our two Canadian maiden speakers in this debate and recognising the very particular contribution they have made to it. I'd also like to say how glad I am to be able to follow my noble friend Lord Garner, for he and I served in the Commonwealth Relations Office together some 20 years ago. There is, I suppose, something symbolic in the fact that last week your lordships considered the problems of the smallest, remotest, least important dependency of the Crown, Pitcairn Island, and today we're dealing with those of the greatest, oldest and most important Commonwealth country, the Dominion, or more accurately, the Kingdom of Canada. When the Canadian constitutional issue arose, I was greatly alarmed, as I know there were many others in this country, because one foresaw the possibility that the United Kingdom Parliament might find itself having to arbitrate between the rival constitutional claims of the Parliament in Ottawa and those of the several Canadian provinces. I therefore advanced the argument that under the Statute of Westminster, we had the right to divest ourselves of our residual responsibilities for the Canadian Constitution without first having to receive the request or obtain the consent of the Ottawa Parliament so to do. The repeal of a United Kingdom Act, or part of it, does not involve the passing of fresh or new legislation which extends or is deemed to extend, in the words of Section 4 of the Statute of Westminster, to a dominion as part of the law of that dominion. I claim that it merely involves the divestment by Great Britain of certain responsibilities, which, as a sovereign parliament, we are entitled so to do.
We would not be legislating afresh for Canada. We would not be imposing any new law on the Canadian people. If our action left a constitutional hiatus, the simple and proper remedy was open to the Canadian Parliament to fill the gap by enacting their own constitutional instrument. Indeed, my noble friend, Lord Stewart of Fulham, referred to the problems that would have followed in how the Canadian Constitution or the British North America Act in Canadian terms should be amended. But this was not our responsibility to decide that. It was the Canadian Parliament's responsibility, and indeed that is the responsibility which has now been undertaken through the bill that is now before us. I argued that the Constitution which would result if we repealed unilaterally, so to speak, the sections of the Statute of Westminster concerned, would have established a constitution for Canada which in Kipling-esque languages would have been native-born, and not one, as in the present circumstances, has to be blessed and legitimised by enactment here at Westminster, and therefore may quite possibly become the subject of controversy at some later date. I still think that my view was in accordance with the letter, if not of the spirit of the Statute of Westminster, which after all was passed in very different circumstances more than half a century ago. I felt at the time that I was being more Canadian than the Canadians. No doubt we have a responsibility to negotiate and evolve a constitution for dependent territory, for Zimbabwe or perhaps Pitcairn Island in the present era. But for independent Canada, which has been such a powerful influence in the whole process of giving constitutional and political independence to a host of erstwhile components of the British Empire, to have to come to Westminster in 1982 to have their proposed constitution enacted by the Queen, Lords and Commons of Great Britain, seemed to me, and still seems to me, to be, as I think my noble friend the Foreign Secretary said, a grotesque anachronism, and contrary to the whole spirit of the sovereign status of the Commonwealth countries since 1931. My view did not, however, commend itself either to the government here or to political and legal circles in Canada. And I can, of course, really understand why. But I thought it might help to concentrate the provinces and the Canadian government upon finding a solution to what was, after all, their problem. Since then, for the last 18 months, we have been inundated with letters, hansards, and addresses from the first, second, and subsequent nations of Canada. We have, as a result, learnt more about Canada, at least I have, and its politics, than I would think I'd ever have learnt in any other way. I think most people in this country thought that the Eskimos lived in Greenland and the Red Indians in the United States. We now know that Canada has a native problem of its own. During my service in the Commonwealth, I was always aware that the Canadian government and public opinion were looking over our shoulders with alert and critical eyes to ensure that Great Britain and its servants dealt in humane and enlightened manner with native peoples with whose welfare history had entrusted our country. There is today, my lords, an almost irresistible temptation to take advantage of the fact that the boot is now on the other foot, to lecture the Canadians as they have so often lectured us, sometimes in tones of an almost Scandinavian degree of moral superiority, as to how we should handle the problem of minorities and of native peoples in various parts of the world. Indeed, I'm afraid I take the noble Lord Stewart of Fulham's motion as having failed to resist that temptation. And I can understand very clearly that anyone listening to the noble Lord Soper's speech, who was a Canadian, would feel the same indignation that I've often felt when the Canadians have criticised and lectured this country on how it should conduct itself. My lords, there is no need for this process. Successive Canadian governments have sincerely tried to practice what they preached. The Canadian government, either provincial or central, has largely, if not entirely, financed the campaign of the first people of Canada in relation to this bill, so that their case could properly be presented at Westminster and the British courts. No one here or in Canada has the slightest grounds for alleging that in this respect they have not been fairly treated. Canada was the first Commonwealth country to set up a special department of government to extend and administer aid to developing countries. Certainly it was from this that we got, I think in 1959, the idea of setting up our own Department of Overseas Aid, the abolition of which I and many of your lordships now greatly regret. Canadian troops have taken part in many United Nations peacekeeping forces to parallel their generosity in providing money for development. Quite apart from the fact that constitutionally any commitments by the Imperial Parliament or the Crown to the Indian or Eskimo peoples of Canada were transferred irrevocably in 1931 to the Queen and Parliament of Canada by the Statute of Westminster, we can, I believe, very sincerely be as confident that those commitments will be observed as if, under British law, we still retain these responsibilities here in the United Kingdom. My Lords, I personally hope that once this bill has been debated on second reading, the remaining stages will be passed by your lordships as a mere formality. I accept that one province, Quebec, whose interests have been very ably represented over the last 18 months by the Agent General, Monsieur Loisel, maintains its opposition to this constitutional instrument. But, my Lords, it's not for us to try to arbitrate or to amend, and least of all to reject a measure which comes before this House as a result of a political anachronism, but which represents the decision of the elected Parliament of Canada as to the rights of its peoples and the structure of its government, and which achieves a constitutional solution to a problem which should have been solved half a century ago. Perhaps your lordships will allow me to add this. Whereas when the patriation issue was first raised, there seemed every likelihood that it would end in an unseemly and potentially disastrous confrontation between Canada and Great Britain. The outcome, in contrast, has been to enable us here in Westminster better to understand and I think sympathise with the problems of maintaining unity and good government in a great federal state. For this we have to thank the willingness to compromise on the part of the Canadian Prime Minister and his colleagues in the vast majority of the provinces. We have to thank the judicial role of the Supreme Court of Canada, and we have to thank the effective diplomacy of the Canadian High Commissioner and her staff here in London. I am quite certain that with the passing of this bill through Parliament at Westminster, the enactment of Canada's constitutional instrument by the Queen and Parliament of Canada in Ottawa, relations between our two countries will be closer on a basis of mutual respect and understanding than at any time since 1867. I can only add, speaking personally, that if by any unhappy chance some future government of the party or parties opposite were to drive me into political exile, I'd be very happy to live under this Constitution, preferably in that most beautiful and God-endowed country outside Britain, at any rate, as far as I know, the province of British Columbia.
My Lords, I intervene with great hesitation because I am an expert neither in Canadian affairs nor in constitutional law. And I intervene only because of the conviction in my heart that the passage of this bill is likely to be calamitous to the future welfare of the Indigenous people of Canada, and that we have an obligation to say and to do what we can through the passage of this bill to influence and try to avert that calamity. Normally, when one would not dream of intervening in a matter which has been settled by the democratic institutions of a sovereign state. But, my lords, this question of the future of indigenous minorities is not a normal question. It is a human rights question, a moral question, a question which transcends the normal considerations of respect for the sovereignty of one people for another. And in all that I have read of the proceedings in another place, I was heartened by the cross-party alliance of members on every side of the House, led by Sir Bernard Brain on the Conservative benches and Mr. Bruce George on the Labour benches, an alliance which I'm sorry has not yet been reflected in the debates in this House. My lords, one of the crimes of modern history has been the treatment of indigenous peoples. One throws no stones this afternoon at any particular country in this regard. Many countries have been responsible and few have a record without blemish. It has amounted in some cases to the physical obliteration of a people, and in other cases to the virtual obliteration of their cultural dignity, for reasons invariably of greed for the land and the resources which those peoples, where those peoples live. It has happened in Australia, in South and Central America, in the United States, so that the process in some cases is irreversible. And honourable governments and dishonourable governments alike have played their part, and perhaps sometimes unwittingly and unthinkingly, in the attack on indigenous cultures. My lords, against this background, an international public opinion, a public opinion too generated by the voices of the indigenous peoples themselves, has begun to assert itself. It is reflected in the International Covenant on Civil and Political Rights, which the Right Reverend Prelate, Bishop of Chelmsford, referred to. The clauses that give to all peoples the right of self-determination, and to ethnic minorities the right to enjoy their own culture and to profess and practice their own religion and to use their own language. These are difficult concepts in international law, but they have helped to encroach upon the absolute right of the majority to dispose of the territory and peoples in their country as they wish. Now, my lords, the history of Canada has been somewhat different. Despite the exploitation and the repression, and until recently the most grossly discriminatory laws, and the history of which my noble friend Lord Soper so eloquently spoke, the Indigenous peoples of Canada have maintained their identity and their culture, and have demonstrated to so many of us in the last months and years with what eloquence and dignity and moderation they can plead their case. My lords, one of the reasons I would suggest why that is so is because of the royal proclamation that was made by the British Crown, because of the solemn treaties that were entered into and thought of so seriously on both sides in years gone by, and because of the persistence of the British North America Act as part of Canadian law which made it more difficult to encroach and ride roughshod over Indian claims. You see, my lords, these rights, which were guaranteed by the British Crown and which have received the protection of the International Covenant, are not convenient so frequently to the authorities of a national state. And that has been the case with the Canadian federal and still more provincial authorities. I believe from everything that I've read that many Canadians recognise that the part that they have played in the history of the Indigenous peoples has been not one of pride. But what worries me, my lords, is that there does not seem to be any firm resolution to change that past into a different future. It was only 13 years ago that a white paper was published by the Canadian government which advocated a policy of assimilation of the Indigenous peoples into Canadian society. And I share every word of what the noble Lord Soper said about that. That, of course, could not be immediately put into practice because of the British North America Act. And it cannot, I believe, be coincidental that it is fairly soon after that that this request for patriation is made. It cannot be coincidental that the consent of the provinces was obtained by the watering down of the one clause which gives protection to the Indigenous peoples. A compromise, as the noble Lord Carrington said, but a compromise in which the Indigenous peoples had no say. My lords, what has been missing, and it's not only in Canada that this has happened, has been any spirit of partnership or consultation or treatment of the Indian nations and the other Indigenous peoples as equals deserving of dignity and respect. Like other noble lords, I congratulate the noble lords, Lord Shaughnessy and Lord Rodney, on the clarity with which, in two languages, they delivered maiden speeches today. But I must say to the noble Lord Shaughnessy that I cannot accept that there has been consultation with the Indigenous peoples about this constitution. Indeed, only a few days ago, the Prime Minister wrote that there would be no consultation until after patriation had taken place. Lords, much of what is said by the authorities in Canada is not shared by many, many Canadian people. And I think that we should pay tribute to the outcry, to the Canadian people for the outcry with which they greeted an attempt which was made to exclude Clause 35 altogether from the Constitution. But, my lords, the failure to discuss and to consult is all the more regrettable in the light of the moderation of the Indian point of view. My lords, these are not separatists. These are not people who are blindly against development. To give an example, they would accept the passage of an oil pipeline through their territory, but would wish that pipeline and its constructors to take account of the migratory path of the caribou across its trail. My lords, what then, if this is what we feel, must we do? The courts have authoritatively declared what the legal position is, although the Indian nations, of course, had no part and had no knowledge of the transfer of responsibility for the maintaining of their treaties from Britain to Canada. But, my lords, the courts may not exercise jurisdiction, but Parliament has responsibility, for this is why we are here. And the Right Reverend Prelate also mentioned the opinion that was given on this bill by Professor Fawcett, a most distinguished expert in human rights, who said that it was the right and responsibility, both under the International Covenant and under the Constitution, to examine this bill and make any changes in it that are called for by the international obligation or by a fair regard for the rights of the Indian nations. Lords, we're entitled, I think, to say, yes, of course, there must be patriation of the Canadian Constitution, but not yet. Not yet before the litigation before the British courts has been concluded. Not yet before Indigenous peoples have at least been brought into the discussion about this Constitution, and not, as it were, put off with an invitation to a constitutional conference, not before, but after the Constitution itself has been passed. Not yet before this vague phrase, existing, has been in some way explained and defined. Lords, how we bring that about is very difficult. I certainly would not wish to vote against the second reading of this bill, because I don't think that it is our business either in this House or perhaps in this country to vote down a bill of this kind. But, my Lords, the committee stage must be the place for considering how we can bring in this element of delay or request to Canada to take these views into account. But, my Lords, we come perhaps finally to the motion which is to be moved by my noble friend Lord Stewart. I find myself confused by this motion. It has concentrated our minds on the issue of the indigenous peoples, and I welcome it for that. But when I read the terms of the motion, I am bound to say to the House that I am not confident at present that the Government of Canada, in consultation with the representatives of the Aboriginal peoples, will use the provisions of the bill to promote their welfare. I am the reverse of confident. I am apprehensive and I am sceptical. And so, to judge from what he said was my noble friend Lord Stewart. The Indian nations have pleaded that the Canadian government should do something to give them grounds for confidence. But they have received no meeting and no discussions, and indeed they have received the watering down of the Constitution provision which mentions them. I cannot in conscience vote for a motion which says that I am confident of something of which I am not confident. Nor by abstaining can I say, or let it be said, that I am not sure whether I am confident or not. And I must, if this motion is proposed and pressed to a division, vote with reluctance against it.
Lords, although we should not vote against this bill, and I accept that we cannot amend it, in my opinion, we owe it to the people of Canada to consider carefully what we're being asked to do. Like the noble Lord, Lord Gifford, I too have studied the effect of the bill on the Indian peoples of Canada, the Aboriginal peoples, who have expressed to me, as to him and to other noble lords, genuine fears about its effect. And I've considered whether their fears were well-founded or not. I would invite your lordships to consider first what the bill does for them, because on these matters its terms are perfectly plain. Whether there has so far been consultation or not, I think that one must accept that there's certainly been no formal consultation, and we have to accept at its face value the statement of Mr. Trudeau that he did not intend to have any formal consultation until the bill was on the statute book of both countries. But it is surely something worth recording that when a constitution is to be held, a constitutional conference is to be held under Part 4 of the bill, the Aboriginal people are to be represented at that conference. And Clause 37, subsection 2 of the schedule makes that quite clear. Now, my lords, I wonder if I may just ask you to consider Clause 25 in detail, because it is very important. It says the guarantee of certain rights and freedoms shall not be construed, that means construed by the Canadian courts, so as to abrogate or derogate from any Aboriginal treaty or other rights or freedoms that pertain to the Aboriginal peoples of Canada, including those recognized by the Proclamation of 1763, and this is important in relation to Clause 35, any that may be acquired by the original peoples by way of land claim settlements. And I take that to mean acquired in future. Well, now, that brings me to Clause 35, about which the doubts have been expressed by the Right Reverend Prelate, the Bishop of Chelmsford, and Lord Soper, and the Noble Lord Lord Soper, the Noble Lord Lord Gifford. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognised and affirmed. I would have thought those words are perfectly clear. But anxieties and doubts arose because of the insertion at a very late stage in the Federal Parliament of the word existing. I must confess that I wonder why that word was thought to be necessary, but it doesn't worry me, however, about what its effect would be, because I don't think it has very much effect either way. However, the Indians are worried lest it has an adverse implication. My own view is that although the word existing is unnecessary, the provisions of Clause 25 would prevent a construction of Clause 35 contrary to Indian interests. So that on that point I would like to feel that Indian fears were set at rest. My Lords, in view of these considerations, noble Lords may wonder what the Indians are worried about. And I must say that I do feel that some of the things of which the noble Lord, Lord Gifford, reminded us do give rise to concern. Having met several of their tribal chiefs here and their representatives, I find that the tribal chiefs were dignified, articulate, intelligent, and above all, they were filled with a touching faith in the influence and benevolence of your Lordship's house. They were genuinely worried. They pointed out that the safeguards in clauses 25 and 35 could be swept away by the power to amend the Constitution under Part 5 of Schedule B, the proposed provisional Constitution. Now, my Lords, although the procedure for amendment is fairly elaborate in Part 5, the Indians fear, rightly or wrongly, that it might one day be used to deny them their rights by altering clauses 25 and 35 to their disadvantage. And when one asked them why they feared that happening, we found that, as the noble Lord, Lord Gifford said, they have long memories. They know about the policy of de-Indianization and assimilation, first attempted in 1840, and then put forward in a white paper of the Canadian government in 1959, and not abandoned until 4 years later, after much protest in Canada. They knew that although the Act of this Parliament, of our Parliament, of 1867 gave them the right to vote, it was taken away from them, or their grandfathers, great-grandfathers, by the Canadian Parliament in 1880, and not restored by the Canadian Parliament until 1960. They knew that they were, for many years, denied the right of access to the Canadian courts for the assertion of their rights until 1950. And as the noble Lord, Lord Shaughnessy, pointed out in that most attractive and very telling maiden speech, there have been blemishes. There have been blemishes in the treatment of the Indians. They have sometimes been deprived of their land without lawful justification. And today, many of them do feel deprived and frustrated and are depressed. And the land claim settlements often cause disappointment to them. And so, my Lords, I do think we have to consider what we can do to help them, to encourage them. without in any way interfering with the internal affairs of Canada, because that would be the worst way that we could attempt to help. Clearly, we should not vote against second reading or try to amend the bill. But surely we can express the hope that the governments of Canada and of her provinces will wish to prove to the Indians and to the people of Canada and the United Kingdom that they mean what they say in clauses 25 and 35 of the schedule. And they will also be able to prove to the Aboriginal people of Canada that those peoples will be allowed to live their own lives on their lands in the way which they prefer and know best. It is sometimes said that they are trying to get the best of both worlds. Well, I don't find anything very wrong in that. I happen to have some Scottish blood in me. And there are people in the Highlands of Scotland, crofters, who were very depressed for a long time. They stayed there, they followed their local ways of life. And then came the great oil terminals. And they benefited, many of them, not all of them. Many of them have benefited from that. And we don't resent that happening. So why should we say that the Aboriginal people of Canada should not have their fair share of modern development, of modern technology, when it comes their way? My Lords, the motion of the noble Lord Stewart of Fulham, who is a very old parliamentary friend in the non-political sense, if I may put it that way, of mine. We've known each other for many, many years, and I deeply respect him. But I do implore him and his colleagues on this occasion not to place us all in a rather embarrassing position by moving that motion. The message has got across, it's on the order paper, but I do not think that it would help. Finally, my Lords, the only other point that I wish to make is this, that there is further protection for the Aboriginal peoples of Canada and other Aboriginal peoples, if their rights can be asserted, in the Universal Declaration of Human Rights, in particular Article 2 of the sort of prelude to it, what is called the Proclamation, and also in Article 2 of the Genocide Convention. It's not an offensive thing to mention because it's in very broad terms. And it reads, paragraph C of Article 2 reads, deliberately inflicting on the group, that is, an Aboriginal group, conditions of life calculated to bring about its physical destruction in whole or in part. I'm sure that no Canadian government would wish to do anything of that kind. And so, my Lords, having very carefully considered the position of the Aboriginal peoples, I hope that one can do something to set their fears at rest. But at any rate, what perhaps is most in their favour is that in all this, the honour of Canada is at stake.
Yeah, yeah.
My Lords, may I first add my congratulations to those that have already been given to the noble Lord Shaughnessy and the noble Lord Rodney. I doubt whether we could have had two more expert members of your Lordship's House in attendance on this occasion. My Lords, it is with some diffidence that I rise to speak on this most important bill. I do so because I've had close relations with Canada for many years, both family connections and the fact that I had the privilege of being with the Canadian Army from the Beaches to the Reichswald. And most of that time, I must confess, was with the French-Canadian Brigade. and I'm not sure, to be quite honest, who I was most frightened of. Since those years, long ago, I have paid many visits to that superb country, both on business and pleasure. And the friendships which I made long ago, I still keep. I admit that this country's involvement is to some extent out of harmony with the present. And therefore it is my view that no one could possibly object or raise any reasons of opposition to the Canadian Bill inasmuch as it causes the Constitution to be patriated to where it rightly belongs. Indeed, the Canada Bill goes far beyond the objectives of patriation. For what will in fact be our last intervention in the internal affairs of Canada, we have before us a 60-clause bill. It is not for me, my lords, to judge the merits of these changes. They are for Canada to decide. It is her future and hers alone. The Canada Bill itself provides a satisfactory method of amending the Canadian Constitution by Canadians in Canada for the benefit and the future of Canada itself. Yet, my lords, on the one hand, we're told that the British involvement is undesirable, and with that I agree, that our intervention is but a residual power, and with that I do not disagree. Your lordships will know that the province of Quebec opposed some of these changes that are contemplated. Far be it from me to comment upon the objections or to pass judgment upon the reasons for those objections. But what we must not overlook is that never in 115 years of Canada's Constitution have changes been made in the legislative powers of any province without the consent of that province. What we're about to do, my lords, will in fact result in major changes in that Constitution, the Constitution of Canada. But this is not really a matter for your lordship's house, or it won't be, I imagine, very shortly. That is a matter which must rest in the hands of Canada. And I cannot for a moment imagine a pair of hands that are not more capable of dealing with their own future. However, we must all hope that the fear of the province of Quebec can, or the fears and apprehensions they have, can be resolved. I'm sure we all know that Quebec is the homeland of one of the founding peoples of Canada. Yet once, and for the first time in the history of Quebec, and for the whole of Canada, can the legislative powers of one province be changed without the formal consent of that province. I am concerned, my lords, as to whether really sufficient consideration has been given, as other noble lords have mentioned this evening, enough consideration being given to the minority interests in Canada. I'll not go further than that because it has been amply covered already and doubtless will be referred to later. And I realize there are many speakers yet to follow. I'm satisfied from my knowledge of Canada that the problems will be solved, that they will be solved justly in the end in the interests of all the peoples of Canada. The noble Lord, Lord Allport, referred to the Agent General of Quebec. I would also like to express my appreciation to Mr. Loisel for the advice, the information that he has so readily provided, and in fairness, in most cases, completely unbiased. May I end, my lords, by saying that my admiration and respect for Canada is such that I have every confidence that whatever the problems and whatever our fears may be and have been expressed in your Lordship's house this evening, that they will find an acceptable and generous solution to all those who are concerned. I do not propose to speak further tonight, my lords. There was much I would have liked to have said, but there is a long list before us and time passes.
My lords, I would like to add my congratulations also to the notable speeches by the two maiden speakers, and I hope they will speak many times again. Some 36 years ago, I began to teach a subject in Oxford called PPE, Philosophy, Politics and Economics. I, in fact, taught it as the successor to the noble Earl, the Earl of Longford, in Christchurch, and I'm sure I was nothing like as good a tutor as he was. But one of the subjects which used to come up under politics was the question of federalism. And I can remember discussing the problem of Canada even in those days and observing to my pupils from time to time that sooner or later that problem would blow up and would be a very difficult one indeed to solve. I said that it would cause much trouble. Well, my lords, I am only relieved that in fact the whole affair, when it has, if I could use the expression, blown up, has gone really very much better, much more smoothly than I feared and indeed expected in those days. My lords, I have very little to add to the wise and learned constitutional points which have been made by the noble Lord, Lord Diplock, and others. I think the House can be in no doubt about the constitutional propriety of the present request from Canada. There can be no question that, in accordance with the ruling of the Canadian Supreme Court, we do have substantial degree of consent from the provinces. If 9-1 is not substantial, what is? And no doubt, there is no doubt too that the other question, which has caused worry to many in another place and in your Lordship's house, that is the question of the position of the Indians or the Aboriginal members of the population. That is also no reason for refusing assent to this bill, the question of Indian rights. Whatever we think, and opinions have been expressed very strongly about the treatment of the Indigenous peoples of Canada, we do not have any responsibility for them here. On this point, the opinion of the legal and constitutional experts is clear and decisive, and I should have thought could hardly be disputed. This is not an affair for the Crown in right of Great Britain, but an affair for the Crown in right of Canada. My lords, in fact, we must trust the Canadian government. And I, for one, find it tactless, to say the least, indeed probably counterproductive, to suggest, even by implication, that we do not trust them. For that reason, my lords, I share the view expressed by my noble friend, the Foreign Secretary, the hope expressed, I should say, that the noble Lord, Lord Stewart of Fulham, will not, in the end, press his resolution. It is innocuous in its language, and one could indeed hardly vote against it. But it gives an impression of paternalistic admonition by implication, which I would have thought is precisely what we ought not to give in our dealings with Canada at this moment. Canada is a sovereign, equal, and independent state, an old partner, a loyal ally. She should be treated as such. We should leave her to deal with her own problems as she thinks fit, my lords, and not seem to be hanging on to some faint shadow of the power of the Westminster Parliament.
Very nice and short.
My lords, I can be brief. The heavy guns of the law have already spoken through the mouth of my noble and learned friend, Lord Diplock. I come along, and I may put it, I suppose, in French, since French is part of the order of our proceedings. I come along as a mere mitrailleur, firing my light ammunition in roughly the same direction and hoping to strike some of the same targets. I therefore can be very short upon the law. I rise because of one anxiety, and that anxiety relates to the rights of the Aboriginal peoples, which have already been the subject, if I may say so, of very eloquent speeches by a number of your lordships. But here, I have also been overtaken by preceding eloquence. My noble friend, Lord Renton, has really said everything that I wish to say about the rights of the Aboriginal peoples, and in particular, he has adopted the approach which I hope the people and government of Canada will think appropriate in this House. I hope also that the Aboriginal peoples of Canada who respect this House will also see the wisdom and sincerity of his approach. My lords, clear already, I hope, that I welcome this bill, and, if I may say so with respect, I add my humble wish to that of the majority, the great majority of your Lordship's House, that this bill will pass quickly and in a way which does honour not only to our relationship with Canada, but does honour to the sense and sensibilities of the British people. But the bill I welcome for a number of reasons. First, it does give us, as so many speakers have already emphasised, the opportunity of ending an anachronism and an anomaly. Speakers have indicated already how absurd it must be that the Parliament of the United Kingdom should retain, as still up to this moment it does retain, ultimate responsibility in a legislative sense for the Constitution of Canada. But I also welcome the bill, if I may respectfully say so as an English lawyer, for its own intrinsic quality. I hope some of your lordships have had time to consider in detail part 1 of the bill, entitled The Canadian Charter of Rights and Freedoms. This is a magnificent modern statement of the human rights and freedoms which the common law countries of the world seek to maintain in various ways. Of course, it can be criticised here and there, but it's a magnificent contribution to the jurisprudence of human rights, if I may respectfully say so to my Canadian colleagues. Secondly, I very much welcome Part 5 of the bill, Part 5 of the Constitution Act, Schedule B. That is the part in which the draftsman has sought to reconcile the age-old dilemma in constitutional matters. That is to say, ensuring that the rights granted by the Constitution are safeguarded, or as the trendy phrase is, entrenched, while at the same time preventing it from becoming, or from developing the rigidity of the Medes and Persians. That's to say, there must be the capacity for amendment, but that capacity must be such that it doesn't interfere in any hasty way with the constitutional rights. That, it does seem to me, with respect, has been achieved. And therefore, since we are discussing the bill, and I'm sure that a word or two of praise from this country will not go amiss or be regarded as patronizing in Canada, let us praise. This is fine constitutional legislation by and large. And yet, my lords, I have one anxiety. Does this new constitution sufficiently safeguard the rights of the Aboriginal peoples of Canada? Now, my lord, first of all, one must address oneself this question. Have we, in the Parliament of the United Kingdom, any right to discuss that matter at all? Now, my lords, it's certainly true, as my noble and learned friend Lord Diplock emphasised, that our courts have no right to consider this matter at all. But, of course, our courts act judicially. Our Parliament, until this bill becomes law, retains a legislative responsibility. And that legislative responsibility rests with us as one of the two houses of Parliament, and it is not a responsibility that could be shelved by participating in a mere rubber stamping activity. We have to look at what we are being asked to legislate. And yet, that legislative responsibility is itself limited. It is limited by the preamble to the Statute of Westminster, to which the Foreign Secretary referred, and it is limited by the conventional practice of our Parliament in legislating for Canada only at the request and with the consent of the Parliament of Canada. It follows inexorably that in a legislative capacity we can examine the bill, we can criticise it, but at the end of the day we can only pass it or reject it. What we cannot do, because it would be wholly inconsistent with the preamble of the Statute of Westminster and our constitutional convention, and it is our constitutional convention, what we cannot do is to amend, because to amend would be immediately to legislate other than at the request of the Parliament of Canada. And therefore we have only the one choice, and I am sure that your lordships are going to exercise that choice in the way which it is quite obvious I, for one, favour, and that is pass this bill. My lords, nevertheless, I welcome the motion put down by the noble Lord Stewart of Fulham, not because I want or would ask the House to divide on it or that it should be pressed, but it has, and one can see this in the course of the debate, concentrated our minds wondrously on the rights of the Indian peoples. And that is very valuable. I do not think for one moment that Canada is going to resent constructive and friendly criticisms or expressions of anxiety about the future of the Indian peoples, or will resent an expression of sympathy with them in their anxieties, whether at the end of the day we share them or not. Noble lords have already indicated with what understandable justification the Indian peoples are doubtful and apprehensive about their future. But we'll just look now for a moment or so at the provisions of the bill. I entirely agree with the analysis of the noble Lord Renton of Section 25, which of course is part and parcel of the Charter of Human Rights, and Section 35, which is the constitutional affirmation of their existing rights, which comes in another part of the bill, which is therefore wider in scope than Section 25, which is limited only to the impact of the Charter on the Indian peoples. But as the noble Lord Renton said, these two sections will, of course, be in the hands of the courts. And when the Canadian courts come to consider, as no doubt sooner or later they will come to consider, the meaning of the word existing in Section 35, which affirms the existing rights of the Aboriginal Peoples of Canada, the courts will immediately, all judges of the same, will immediately look back for guidance to Section 25. And what do we find in Section 25? We find a most useful indication as to where those existing rights are to be found. In the Proclamation of 1763 and in the land rights, or the rights of the Indians to land settlement. So, my lords, if one just takes this Constitution as it now stands and assume it to be under discussion in a court of law, there can't be any doubt what is being protected in Section 35. And if there were any doubt, Section 25 throws the most valuable light upon it. And I have little doubt that the Canadian courts would pay heed to the eloquent speech of my noble and learned friend Lord Denning, Master of the Rolls, in giving the leading judgment in the English Court of Appeal, where he described the Royal Proclamation, which is expressly mentioned in Section 25, as a Bill of Rights, not as a treaty, because courts of law municipally are rarely concerned directly with treaties, but as a Bill of Rights, an Indian Bill of Rights, not to be altered without the consent of the Indian peoples. And so, my lords, there is much in those two sections which I would suggest to the Indian peoples, much to give them confidence for the future. There's a further matter upon which the noble Lord Renton touched, but which is also important. Although the Constitutional Conference, which is to take place within a year of the Constitution coming into force, is strictly a constitution between the Prime Minister of the Federation and the Premiers of the provinces, yet it does provide, and I use the words of the Constitution advisedly, it does provide for participation in those items under discussion which deal with the identification and definition of the rights of the Aboriginal peoples. My Lord, I'm sure the Indian people would have preferred it if it was a conference of which they were members, full members, like the premiers of the provinces, but it is a conference in which their participation is required by law when it's dealing with the identification and definition of their rights to be included in the Constitution. So, my lords, there is some safeguard there. Where, therefore, is my residual anxiety? It is in Part 5, which I've already praised in general terms, that my anxiety comes. The Indian peoples fear, or their leaders fear, that they do not have the safeguard that, for instance, the provinces have against amendment of the Constitution without their consent. My lords, I say no more than that I do hope that those in Canada who, as one can see from Canada's record, are just as alive to the importance of human rights as we are in the United Kingdom, will look at that particular point. If something could be done there, I would suggest to our Canadian friends, much would be achieved in the gaining of the confidence of the Indian peoples. There's another less important matter which also, I think, causes some anxiety. There is provision in the Constitution for recurrent constitutional conferences every 15 years or so. And indeed, the Part 4, which deals with the first constitutional conference, is repealed a year after the Constitution has been enacted. There is no similar provision for those subsequent conferences for the participation of the Aboriginal peoples. That may be inadvertence. I can't believe it is policy. I would hope and express the hope that Canada would take a look at that so as to ensure that at least the participation envisaged in the first Constitutional Conference would continue in the following two. My Lords, I have done. I sincerely hope that the Aboriginal peoples of Canada, having read some of the very eloquent speeches delivered by your lordships, will appreciate that the one desire of this House is to help, not to advise, not to patronize, not to dominate, but to make helpful and constructive suggestions as we bid bon voyage to Canada on her voyage into the future. And in wishing them bon voyage, I would like to tell them that we have had the true ring of Canada in the course of this debate in two admirable and eloquent maiden speeches by Canadian members of your Lordship's House.
My Lords, it's always a pleasure as well as an honour to follow the noble and learned Lord Scarman. But I am not going to make a speech or refer to the bill. I am going to make a very short intervention. And it is because I visited Canada for the first time in 67, when the Expo 67 was on. And there, at the entrance to the pavilion, there was a plaque. And on the plaque, I would like to read to you the words. They're not very long, it's quite a short thing. And on the plaque, there were these words: "You have stolen our native land, our culture, our souls, and yet our traditions deserve to be appreciated, and these derive from an age-old harmony with nature and successful in tracing the original version," you see. Now, these words I found very moving, and it seems to me that however good this bill is, and I'm not going to refer to it, it seems to me that I don't believe that here in this country we are aware of the implications of what this plaque, the words on this plaque, says. And so I've very little to add to my views on this. Many people are worried about the Canadian Indians and the way they have been treated and the way the Canadians should treat them. And it seems to me that is their business, not ours, and we can only just watch carefully what is going to happen in that country.
My Lords, the last time I heard a Canadian amendment in this House, the House stood absolutely quiet, and the only speech was from the late Lord Bennett, who'd been Prime Minister of Canada. It is true today we've had two excellent Canadian speeches, for which we are extremely grateful. And if I may say, it shows the extreme versatility of the members of this household. Now, I have certain traditional relations with Canada, particularly with the residential settlement in the prairies. I've been there fairly often over a period of some 50 years, but perhaps my most vivid memory was being responsible for taking young aircrew from Canada through their operational training before going to operational squadrons. They represent a magnificent body of men to whom I'm greatly enriched for having had the opportunity of meeting, and who represent a country which we can have every confidence in. My Lords, I think we shouldn't underestimate in this the extraordinary difficulty of governing a country like Canada. If I may give one simple example, if today we were sitting in Victoria, in Vancouver Island, the eastern seaboard would be the other side of Mongolia, the Republic of Mongolia. And it's just about as diverse as if we were taking a line across Scandinavia and Asia. It's a tremendous problem. I wonder, whether noble lords are right in saying that the proposals before us today are anachronisms. I believe Canada has been wise enough to wait till the sense of unity in the country has reached a stage, really, when a constitution can be written. Now, we know that this constitution has not been without considerable controversy in Canada. There are certain definite reasons, but I believe those controversies would have been even more difficult to resolve had they taken place in an earlier period. I think one must say this, quite frankly. These proposals have never been before the electorate in Canada. There was nothing in the Liberal manifesto at the last election to deal with the subject at all. A great deal of this stuff has never been discussed in public at all. The noble Lord Scarman, of course, is extremely keen on human rights. But there are a great many lawyers who are very doubtful indeed about this, which has never been properly examined. If I may give a simple example, if anyone is arrested, the first thing he'll do will be to appeal to the Constitution, and he'll have an appeal. Now, he may lose the appeal, but it will mean the delay in criminal prosecution may well be very considerable indeed. Now, it's one element. And I don't think many people will, with great confidence, interpret all the terms in the Schedule of Human Rights. But the other thing which I think is a pity, and it's a great pity, and that was there was no consultation with the Indian people before this took place. It's all very well to refer to conferences, you know, we all have conferences, and they can mean a lot or little. I should admit here to being an honorary chief of the Saulteaux Indians in Manitoba. I mean, the problem which the noble Lord Garner brought up, the conflict of two cultures, is one which has no easy resolution at all. I should have said the noble Lord Renton had fully shown that as much was done in this bill as could be done. But this doesn't answer, basically, their problem. They don't believe in democracy. They don't vote. There's no member of the in the federal government, in the federal parliament at all. They don't think this is the way to conduct affairs at all. They have their own way of living, and they don't want to become Canadians. They want to remain Indians. Now, these are fundamental questions, which, quite frankly, we can't resolve by law. It doesn't permit it to do so. It is a very difficult question for the Canadian government, who I know approached this with the utmost sympathy and difficulty. And I think our interest in this today, whether we accept this amendment or whether we don't, I think the early phrases which Lord Stewart has put in, that we regard with confidence the appeals, and we've had a massive volume of appeals in this country from the Indians. They are concerned at our future. You know, it's not altogether dissimilar, if I may draw a comparison, with the occurrences in the Highlands of Scotland. Here you have a London government with a language they don't understand, with customs they don't understand, with a form of land tenure they don't understand, and all up against the irresistible forces of economic development. That's a very similar position, very similar indeed, and it is to a great extent a task of administration. Now, I don't think we can do much about it. I don't think we can do more than say that we are concerned with it, because, after all, we're taking the excuse of this bill to discuss what are, in fact, internal matters in Canada, and they will no doubt take it that way. But I rejoice that the Canadians have got this ability to amend our Constitution. I can't say that I've ever, in any time I've been in Canada, heard Canadians complain that we still held the power of constitutional amendment. I don't think they feel very strongly about it at all. I do think it's a pity that the Canadian government didn't appreciate the correct constitutional position until it was pointed out to them by the Supreme Court. But I believe this will have, and the controversy that's been there, will have a tremendous unifying effect on Canada. And I would like to suggest something else. That I believe it will have this effect on Canada, that it will regard politics as a more honourable profession and a more important profession than sometimes it has done up to the present time. You know, I would, I think, only commend, if I may, to the Canadians the words of Pericles: the price of freedom is eternal vigilance.
My Lords, I'm in no doubt that we must now accede to this request from the Canadian government in the form which it is now presented to us. And I hope that the House will do so with positive enthusiasm. Now, it is small wonder, my Lords, that an act passed in 1864, which was the first attempt by the British Parliament at colonial enfranchisement, should have had the defect in it that there was no mechanism for the appropriate revision procedure of the Constitution. This was something that was rectified in subsequent acts for Australia and New Zealand. We find criticism of the present proposals now focused on the issue of the protection of Aboriginal rights. I cannot add a great deal to what has been said this evening, but my justification for inflicting myself upon the House after so many eloquent speeches is that I am a somewhat rare species in that as a member of this House, I also am proud of the fact that I have a Red Indian great-grandmother who came from Alberta, and that is the area which gave us two notable maiden speeches this evening, both of whom are old Canadian friends of mine, and with one at least, my family has had a very long connection. And I knew the noble Lord Shaughnessy in Montreal, where I suspect he must have learnt the French that he gave us the benefit of this afternoon, because a French-speaking Westerner is a pretty rare species too. But I do congratulate them both, and I hope that now they have used this excuse of breaking their duck, that we shall hear more from them in future. Now, in addressing this problem of the rights of the Aboriginal people, let us remember one point, which I don't believe has been made very often, that our Queen is their Queen too. And when the noble Lord Stewart talks about A and B and C, it seems to me, although I say so with great temerity in the presence of various constitutional lawyers, what in fact we are being asked to do is the Queen is placing the handling of the native rights which are vested in her no longer in her British agents, but in her Canadian agents in the shape of the Canadian Parliament, which surely must be the appropriate place for these rights to be exercised. And, my lords, it does seem to me that Canadians could be forgiven if they looked askance at our moral right of the UK Parliament to preach to them on the subject of the protection of minority rights. One doesn't want to flagellate ourselves, but we have had Brixton, we have got Northern Ireland, and as the noble Lord Selkirk just said, I'm not wholly sure, as a Scot, that we can be altogether proud of some of the ways in which we have treated the minority peoples of Scotland, and the noble Lord Elwyn-Jones, I have no doubt, would wish to say the people of his native Wales. So let us express our sympathy with them in their problem, as the noble Lord Selkirk did. Let us say we have a long experience in these matters. Let us say that we have some pride in the tolerance we have exercised. But then let us say that we are woefully short of solutions to these very difficult problems. Now, my lords, it's all very well, I think, to talk of long memories, but it does not seem to me to be very productive in looking at history to hark back to deploring the record of the past which is beyond recall, and to judge the actions of those times by standards which are now very different. Now, I don't blame any group for seeking to extract political or financial advantage from a situation when they see it. As the noble Lord Renton said, that is a perfectly legitimate gambit. But I believe that to work up a great head of steam of moral indignation is misplaced. And Lord Shaughnessy pointed out that the record is not all black. And I would say that even if some Canadians, as they do, admit that they are perhaps making up now for a century of neglect, let us recognize and let us see what the record of recent years shows as an earnest of their good intent. And I understand that they now have a budget of over $1 billion for special Indian projects, and perhaps one statistic tells us quite a lot. 10 years ago, there were 200 Canadians in universities. Now, 200 Canadian Indians in universities. Now there are 4,000. What is slightly less reassuring, my lords, is that I understand that most of those 4,000 are lawyers, and whether that bodes well for the future of Canada or not, I am not quite so sure. And it's also worth pointing out, my lords, which I don't think has been pointed out before, that the Inuit, who represent some 10% of the Aboriginal population, have expressed their content with the Constitution. And it is worth also congratulating members of this House, I believe, that they have referred to the Inuit by the name that they prefer to be referred to, rather than the rather derogatory name of Eskimo, which I understand was bestowed upon them by the Indians. My lords, it's late, and I forbear with some difficulty attempting to answer some of the points made by the noble lords, Lord Gifford and Lord Soper. But I do want to say one thing. It is very easy to sentimentalize about the validity of the life of the noble savage. And I don't want for a moment to be misunderstood in suggesting that the life of the Indian is the life of a noble savage. But I have heard people in this country get all sentimental about the life of the West Coast crofter. And it isn't all that marvellous. I suspect that we can misplace some of our sentimentality towards the Indian way of life. I further suspect that this may have something to do with the statistic that the noble Lord Soper produced about the shortness of the expectation of life of the Indians. And I would have thought that one answer to his concern about this was not to complain about a policy of trying to apply the standards of life enjoyed by the rest of the community. But I accept that he was trying to say that the Indians may have been mistreated in the past. If they have, I hope that we have demonstrated that the Canadian government have recognised this and have done something to put it right. Now, my lords, I know many people in this country share with me a feeling of special affinity for Canada, and this manifests itself in common cause in areas like foreign policy, like defence, and trade. I happen to believe we have a long way to go before we reap the full benefits of all the possibilities of the long tradition of trade between these two nations, with which my family has been proud to be associated for well over 100 years. I don't believe the changes in this bill will in practice be very profound, but insofar as there are changes, they will be beneficial to both nations by removing a potential source of embarrassment. So I say, let us pass this bill with a good grace, with no backward glances, and I say to Lord Stewart, please, with no equivocation.
My lords, I wonder if I can begin by telling a story. It will at least make my speech shorter. In 1930, I was called from the chamber of the House of Commons to meet visitors in the central lobby. To my surprise, they were 3 Indian chiefs from Canada, with their squaws. They were marvelously dressed. The men with great on their heads spreading wide, brilliant red robes. The squaws with bells on their wrists and on their ankles. I had to be in the debate, but I got them seats in the public gallery. As the men were members of their regional parliament, they were allowed in the distinguished chambers, distinguished visitors' bench. I remember the sensation when they came in, the bells of the women tingling, so that all the members of the House of Commons looked up to them. Mr. Neville Chamberlain was speaking, and he was very bewildered. I had tea with them on the terrace, asked them their business. They said, when we first meet people, we don't tell them our business. We make friends. And they passed round the pipe of peace. Afterwards, I learned that they had come here because they had supported the British in the War of Independence in America. They showed me on parchment the treaty which was signed by the King of this country, guaranteeing to them independence. And they came to claim those rights. They had such sympathy among members of Parliament that we made an all-party committee which saw Mr. J.H. Thomas, who was then the Colonial Secretary. And Mr. Thomas replied that that treaty no longer had force, that we had handed over to the Canadian government all responsibility for the Indian people. My lords, since then, I've tried to watch the scene in Canada closely. Like many members of this House, I have relatives there. And my general impression has been this, that during this period, both the provincial governments and the central government have sought in legislation and administration to assimilate the Indian population with the whites. They have done that by eradicating the Indian community life, by seeking to remove them from their reserve lands, from destroying their spiritual and cultural character and institutions. In a word, to make them more like white people. My lords, in saying this, I'm not specially condemning the Canadian government. It has been happening all over the world. The strong absorbing the weak. But today, there is a great change. Today, there is a reversal of that tendency. Everywhere, championship of minority rights. I'm amazed how in London here, there are groups of people from all over the world urging the rights of minorities. And my lords, I'm one of those who believe that that is a healthy change, that the best future for mankind is not uniformity, but is diversity and the contribution to us all of many cultures. My Lords, I want to congratulate, if I may, the Lord Stewart of Fulham on the speech which he made. I'm sorry to say that I do not feel that his motion is justified in expressing confidence in the Canadian government. I've got great appreciation of much that Prime Minister Trudeau has done, including the declaration of that country as a nuclear-free territory, though I'm a little disturbed by the negotiations now taking place with America to have cruise missile tests there. But quite frankly, if you look at the policy of Prime Minister Trudeau on this subject, it is not so progressive and reassuring as in other ways. I want only to make 2 points. The first is that whatever the legal niceties of our having handed over responsibility for the Indian community in Canada to the Canadian government, a very great moral responsibility still rests with us. Ironically, the Indians in Canada, when they signed those treaties, deliberately asked that the king should sign them rather than the government, because they believed the king had more constitutional authority. Those treaties were with us. We handed them over to the Canadian government without any consultation with the other parties to the treaty, the Indian community. And I urge that our moral responsibility for the condition of the Indians in Canada still rests with us. Secondly, my Lords, I want to say how disturbed many of us are with the speed with which this bill has been introduced and is being passed through Parliament. At the present time, there are legal proceedings in the courts which deal fundamentally with the legal right of the Canadian government to pass this bill for our decision without consultation with the Indian community who were participants in the treaty. These are not frivolous proceedings. Judge Weinlott, who is presiding over one of the courts, says that the case raises issues of constitutional importance which must be clarified. They're not only not frivolous, the Indians themselves are seeking for early decisions. And I want to urge that it would have been very much better if the government had delayed the introduction of this bill and its passage through the House until decisions are reached by the court. I urge two things: that the bill should be delayed until the court cases have concluded, and secondly, because of our moral responsibility, the government should meanwhile seek assurances from the Canadian government that Indian rights will be observed. My Lords, the Prime Minister Trudeau has said he will negotiate with the Indian community after the bill has been passed. I suggest that our responsibility for the Indians in Canada is so great that we should urge him to enter into those negotiations before the bill has passed. My Lords, if we did those two things, we would justify the confidence placed in Britain by the Indian community in India.
My Lord, the number of speakers who have inscribed themselves for this debate shows the interest and concern which we feel. It also, and I must apologise to the House, deprives me probably of the possibility of hearing the Minister's reply. Most, or many at any rate, of the noble lords who have spoken have had a direct connection with Canada, including the two noble lords upon whose maiden speeches others have dwelt, and whom I would like to join in congratulating. I cannot claim equal intimacy, though the tie I am wearing illustrates the complexity of Canada. It is the tie of an English-speaking university in the French-speaking province of Quebec. I think that noble lords, in dwelling, for the most part, upon the particular problem of the Aboriginal peoples of Canada, have omitted to consider how very peculiar this bill is in general. Because it is not a bill exclusively for the repatriation or patriation of the Canadian Constitution. When the British North America Act was accepted in 1931 from the operation of the Statute of Westminster, because of a Canadian request, that request was made because no formula of amendment had been found agreeable to all Canadian interests, and it was confidently assumed then, and has been assumed since then, that as soon as such a formula was found, a simple bill would be introduced by which British Parliament's power of legislating for Canada would be removed, and a formula for amendment would be affixed to the original Canadian Constitution. Instead of that, we have a bill which is long and complex and includes provisions which have nothing whatever to do with abrogating our own powers or with conferring powers of amendment upon Canada itself. And it is because we have a bill which is so complicated that we are in the quite extraordinary situation of which this discussion about the rights of the Aboriginal peoples merely gives us an instance, that at the very moment when we are hoping to part on friendly terms with this power of legislating for Canada, we are being asked, in fact, to legislate for Canada in a host of areas, all the points covered in the Bill of Rights, which powers which, if an ordinary amendment measure had been carried, would immediately have devolved upon Canada itself. Never before, in fact, since Canada attained its legislative independence has the British Parliament been asked to assume the power for internal legislation to this extent. And therefore, it is not surprising that confronted with this request, noble lords feel, as members in the other place felt, that they are entitled to hold views about the content of the bill, which they would not have felt entitled to had it merely been what was always expected, a request for the patriation of the Constitution. The noble Lord Brockway referred, and rightly referred, to the greater sensitivity felt in all parts of the world today for the rights of minority communities. And it is certainly true that when the Statute of Westminster was amended to accept the British North America Act, no one had any thought of the rights of the Aboriginal peoples. It was the problem of reconciling Quebec to the rest of Canada in an agreed amending formula, which at that time prevented progress. And had there been an agreement, a federal provincial agreement, in 1931, had Canada accepted the operation of the British North America Act in the way in which of the Statute of Westminster and its operation on the British North America Act, in the way in which other dominions were treated, we would not now be discussing, we would not have any more right to discuss the fate of the Aboriginal peoples in Canada than the fate of the Aboriginal peoples in Siberia or anywhere else in the world. We might have a moral right, we might conceivably, under United Nations conventions, have a right in international law, but we certainly would not have had a constitutional right. And it is one of the paradoxes of this bill that for reasons which have nothing whatever to do with the origins of it, we are now asked to deal, or are dealing, in fact, with these matters of Canada's internal policy. I myself must confess to some regret that it has not been found possible to produce an amending formula, or indeed an entire bill, which carried with it the assent of Quebec. I quite appreciate, of course, the points made by the noble Lord Diplock and others that, constitutionally speaking, the Supreme Court of Canada has made it pretty clear that even the conventional demand for assent is met when you have 9 provinces out of 10. But I think one must remember that Quebec is not the 10th province. Quebec is, and has always been recognised, as one of the 2 founding partners of Canadian Confederation. It was the hope of the noble Lord Hume's ancestor, to whom he referred in his speech, that this would not need to be the case, that the French Canadians would be assimilated by the British, as white Canadians now, we are told, hope to assimilate Americans. But a quarter of a century of experience of running Canada as a unitary government broke down. The Confederation that we have represented a partnership between the 2 main founding peoples, and it must surely be a matter of regret that when this bill passes, Canada will have a constitution from which, certainly not the necessarily, and indeed not in fact, all the residents of Quebec, even all the French-speaking residents of Quebec, resent, but still one which has not found favour with their own elected government. For these reasons, my lords, though I do not believe for a moment that we have any option but to pass this bill, it is not a bill which immediately one confronts with lightness of heart. One must hope that in all the respects in which doubt has arisen, Canada's good sense, Canada's sense of its now great opportunities at home and abroad will bring about a satisfactory resolution of difficulties, whether they are difficulties between Anglophones and Francophones or between the white majority and the minority communities. I do not think that having explored this, we can do more than express our hopes. And my own feeling, therefore, is that the resolution proposed by the noble Lord Stewart does not assist what we have in mind, because even to propose a motion of confidence in a friendly government creates a presupposition that there is some reason why some people might not have confidence in it. I do not think that any member of your Lordship's House would welcome an unsolicited testimonial to the uprightness of his life. And therefore, I hope that we will pass the bill. I hope that the resolution will be withdrawn, because to vote against it would be equally, indeed more invidious. And I hope that this last occasion on which Parliament, as a quasi-sovereign authority in Canada, discusses Canada's affairs, will be the prelude for all of us who have enjoyed long contacts with Canada, the beginning, as has been said by other noble lords, of a new and fruitful relationship.
Yeah. My Lords, it is my regret that for other pressing engagements I was unable to hear the opening 5 speeches in this important debate. And I speak as one who is proud that my party in government in 1945 set the pace in granting independence and self-determination to so many parts of the Commonwealth. Therefore, my immediate reaction is to support patriation. And my immediate reaction is that Britain's authority over Canada's constitution must be ended. But my noble friend Lord Brockway did refer to outstanding legal cases. And I believe, my Lords, that we must have information from the government. What will be the position should any of those legal cases be upheld? What will be the constitutional and legal position of the bill which is now before us? Because I believe that is a very important point. And Lords, when the Select Committee of another place was giving consideration to the possibility of a request from the federal government with dissenting provincial governments, that Select Committee said, and I quote, "The UK government is bound to exercise its best judgment in deciding whether the request, in all the circumstances, conveys the clearly expressed wishes of Canada as a federally constructed whole." So, my Lords, in the light of the Select Committee's view, there could have been a possibility of our Parliament not giving assent to a request made to it. And like many other noble lords, I have received massive communications, which I have endeavoured to read as assiduously as I possibly can, and, as other noble lords, also had a number of consultations which have been found very interesting and informative. And it was soon made absolutely clear, if I wasn't aware before, that 8 of the 10 provincial governments were opposed to the then proposals of the Canadian government. If that had been the position in respect of a request that had been made to the United Kingdom, presumably the view advanced by the Select Committee would have prevailed. And I think it's extremely improbable whether our Parliament would have acceded to a request which was rejected by 8 of the 10 provinces. Therefore, my Lords, it's to the credit of the Canadian government and all the provinces that following the decisions of the Canadian Supreme Court, they arrived at a new accord. Therefore, our Parliament has not been called upon to decide upon a request of the federal government with dissenting provincial views. That could have led to an unfortunate constitutional problem and maybe even endangered relations with our friends. I believe the view of the Select Committee, and I hope it's not too presumptuous, and also the strength of the representations made to many members in this House and in the other place, and the way those representations have been received, may have assisted in reaching that accord. My Lords, the snag is that it would appear that the accord and the eventual resolution was reached without Indian consent or meaningful consultation with their representatives. That view has been advanced to many members in this House by the representatives of the Indian peoples. And I would like to feel that the representatives of provincial governments who brought pressure in their representation about their own position will possibly have the same regard to the pressures which have been brought to us on behalf of the Indian peoples. This, my Lords, may be our last opportunity to exercise some views on the treaty rights guaranteed to the Indian peoples by the Crown. And it is the Indian peoples who have expressed their apprehensions of the provisions in the bill as they affect them. And I was so pleased to hear from the noble and learned Lord Scarman that he can understand those apprehensions which have been voiced by the Indian people. I echo also the view of my noble friend Lord Soper, that it's to my shame, I'm certain others will share this view, that until our attention was brought to many of these facts, how ignorant I've been about the conditions in many aspects of the Canadian Indian peoples. This is a problem that we face throughout the world. Things go on of which we know such little. My Lord, there was no reference, as is now in clause 35 of the bill, to the rights of the Aboriginal people in the original federal government's proposals. These were inserted following the accord, but that alone has made the Indian peoples apprehensive about their future because they weren't considered in the original draft. And surely, my Lords, we have a right, irrespective of our parliamentary position, we have a right to express our concern about the position of minorities in Canada as we express concern about the rights of minorities in many countries of the world. There surely can be no difference. There's to be a constitutional conference within a year of the new constitution coming into force. And as has been stressed, the representatives of the Aboriginal people will be invited to participate. I think it is most regrettable that such a conference was not held before the Canadian government actually decided on its final request to the UK. The Prime Minister, Mr. Trudeau, has also offered the Indian people, as has been stressed by other noble lords, to discuss their problems and possible their own suggested amendments to the Constitution after patriation. And I clearly recognise the rights of the federal government and the provincial governments to deal with their own constitution. But in view of the strong apprehensions and representations that have been made to many of us, I believe it would help the situation if some assurances could be given by the federal government before the bill actually concludes its passage through this House and through Parliament. This would help to satisfy not only the Indian peoples, but would help to satisfy many noble lords and others outside this House who have expressed some concern. My Lords, Mr. Richard Luce, Minister of State, in the second reading debate in the other place, he said, "I do not need to remind the House that the Canadian people will be paying the greatest attention to the debate and will be aware of its great significance. I have no doubt that the same attention will be given to the views that have been expressed and will be expressed by other noble lords in this debate tonight. And I believe the motion proposed by my noble friend Lord Stewart is frankly the least we can do, as between one group of friends to another friend, to express quite sincerely what our views are. This, I believe, is an opportunity to convey to the Canadian government not only our felicitations and desire for close accord, but this is really our last opportunity to say to them, this is what we hope you mean in the bill, and you'll give assurances not only to our Parliament, but to the Indian peoples.
I am of the opinion that this bill is being unnecessarily rushed through Parliament, especially as already been mentioned earlier by many speakers, that the Canadian courts have not yet decided important issues which may have an effect on this bill. And as I understand it, it could make this bill unconstitutional. I'm not in opposition to Canada requesting full legislative powers. This is natural and should have been done before. But I see no reason for this desire to urgently pass this bill in days, rather than in months. After all, my lords, Canada has already waited many years. The British government, I think, is in a catch-22 situation. Heads we lose, tails we lose. Because whatever the outcome, large numbers of Canadians are going to be dissatisfied. With reference to the Indians, they have strongly lobbied Parliament and the British people since 1979, when 350 chiefs came to London and impressed us by their sincerity, concern and honesty, and put forward their fears and doubts regarding entrenchment of their treaty rights and our legal responsibility to honour those rights. It is imperative that their culture and ideals are retained and promoted. An important point is that the Indian nations have not been consulted, as has been mentioned again today, in the drafting of this bill, which can affect their future. Decisions have been made for them, but not by them. This has been historical experience for countless generations. Much has been said today of assimilation into society. Assimility regarding equal opportunities for education, jobs and health would be accepted, but not at the expense of culture, traditions and a natural everlasting way of life, which the Indians value so highly. There is no course we can take to amend this bill, and should not wish to do so, because I think the consequences would be far-reaching and damaging for us and for Canadians. It could possibly generate in Canada ill feeling towards the Indians, which may set back what they are trying to achieve. I notice that in clause 25 of the bill, a guarantee is made upholding treaties and rights of the Aboriginal Peoples of Canada, including recognising the Royal Proclamation of 1763. I'm interested in what the noble Lord Trefgar may have to say regarding this, and what representation to the Canadian government has been made. Canada is one of the strongest and closest members of the Commonwealth, and the relationship between our two countries has always had a strong bond of affection. My lords, I'm speaking as one whose father was a Canadian, and I'm very proud of this, and wish the bond to continue and to grow stronger. It is therefore of the utmost importance that proper care and consideration be taken when discussing this bill. The bill, when being debated in another place, did not have a smooth passage, due mainly to the plight of the Indians. We even now are hoping for some change at this late stage. I fear that will not happen. We must accept Canada's wishes, but must do so with a clear understanding of what is being done. I believe and hope that it is Canada's wish in general that Aboriginal rights are respected, and that when this bill is passed, that will be the case. My lords, if we cannot amend this bill, it is only right that we debate it fully. If we passed this bill on the nod, we would have been accused of being a rubber stamp and not carrying out our obligations as we should. If we dictate too much, we should be accused of meddling and be told to mind our own business. It is essential, therefore, that due time and further consideration should have been given in Canada before presenting this bill. I wish Canada success and a prosperous future when this bill is passed, and hope that what we have done in Parliament agrees with the general wishes of the Canadian people, and at the end of the day, the actions we have taken will be respected and appreciated.
My Lords, I'm
glad to follow the Noble Earl Grey because I think, as one has found throughout this debate, a considerable degree of closeness of opinion between us, an unusual degree indeed. I found myself agreeing very largely with what the Noble Lord Biloff was saying, and I felt rather alarmed by this, as a matter of fact, but I hope and believe it's an unusual occasion, and we do have this general feeling of responsibility in this matter, I think. What does divide us to some extent, I think, is how best that responsibility should be discharged. And I think this is the issue rather than the responsibility itself. And this was made clear, I think, by both of the noble lords who made their maiden speeches here this afternoon. And I would like to join in the congratulations which have been extended towards them. And I look forward, like others have said, to hearing them again on some other occasion when what they have to say will not be possibly overweighted as it was today by the knowledge that it was their maiden speech and by the fact that most of them, by the fact that both of them enjoyed a considerable degree of knowledge of the subject. I am not trammelled by that myself. I am no expert on Canada, but I have visited this great country on a couple of occasions, and I hope to go again. And indeed, I have friends living in different parts of Canada. And what I think strikes one as a visitor to Canada is the very great differences, the unexpected differences of political opinion, which exist not only between people of different parties, but people who live in different parts of the country. There is a Western body of opinion and an Eastern body of opinion, and a body of opinion lying somewhere between the two. I have carried out a correspondence over many years with an English friend of mine who lives in Toronto. And he has been highly critical of the government of Canada, of the present government of Canada, not only in relation to their attitude towards the Aboriginal peoples, but also in relation to their attitude to the Quebecers, or perhaps the Quebecois, we should say. He feels, and I think he's right, that the government of Canada, in its attitude over the years, has much to answer for, has left much to be desired, and that we, too, discharged our responsibility in earlier years in a manner which, again, we can't be wholly proud about. But on this particular bill, what he says is this: with 9 provinces supporting the federal government, I don't see how the UK Parliament can fail to pass the requested amendments to the BNA Act. He assumed, I think, at that time that what we should have was a simple series of amendments to the old Act, and not, as it were, a fresh bill. And Lord Biloff has said enough about the consequences of that to make it unnecessary for me to add to it. But I do believe that it is because of the bill does precisely, in relinquishing our own responsibilities, as it were, give us the responsibility of passing those particular responsibilities on, that we do find ourselves in some little difficulty. One other thing my friend says, my Canadian, he's not a Canadian, he's still English, though living in Canada, and my friend who lives in Canada says, which I think is worth mentioning, and I think many of us would agree with this. He says, I think that such a country as Canada should be ridden with a loose rein. And this, I think, echoes a number of points that noble lords have made. Now, in what I hope will be a very brief contribution to this discussions, my lords, I would like to say one other word about the amendment. So far as the bill is concerned, I believe that we are all agreed that we must give this a second reading, and with it our blessing. On the question of the amendment, I rather suspect that my noble friend Lord Stewart, whose opening speech I followed with interest and admiration, was perhaps a little taken aback by the decision of the noble Lord, the Foreign Secretary, to say that he would not accept the amendment. I think my noble friend may have expected that the amendment would be acceptable to the other side of the House. But the fact that it is apparently not acceptable places us in rather a new situation. We have the problem that the government says, well, this amendment is unnecessary because if you say that you are confident in the government of Canada, you in fact indicate that you are not confident. The very expression of that confidence indicates a lack of confidence, and this point was made rather better than I've made it by the noble Lord Belloff. On the other hand, my noble friend Lord Gifford says, as far as he is concerned, the expression of confidence is one which he notably lacks. He says he has no such confidence, and such is his lack of confidence that he could not conceivably go into the lobbies in support of the motion. This, I think, does place us with a problem because we've got different interpretations of what the consequence of carrying the motion is. In these circumstances, it is my hope that my noble friend will think it appropriate in all the circumstances not to push the motion to a division. I'm bound to say that I myself would find it extremely difficult in all the circumstances, the new circumstances that have arisen, to go into the lobby in support of the motion, because I too, to a very considerable extent, share the lack of confidence which my noble Lord and my noble friend Lord Gifford has expressed. Not, however, to the same extent. I would not, in fact, consider for one moment voting against the Act. Neither would indeed I vote against the motion, because I believe that although the record in the past leaves something to be desired, and although the fact that the bill has gone through without what some of us would feel to be adequate discussions, and while certain legal proceedings are still taking place, leads to a certain amount of disquiet. And nevertheless, it seems to me to be quite impossible that at this stage in the proceedings we can do other than give this bill a second reading. And therefore, in these circumstances, I would have to abstain, but I could not conceivably vote against the motion. In all those circumstances, my lords, it is my hope that my noble friend will feel that in the circumstances which have arisen, which he could not have foreseen, I think, when he put the motion down, that he will think it proper not to press it to a division, and then I think we can proceed with the second reading. And what further things we have to say about the bill, and I think many of us will have other things to say, it may be possible to say at a later stage as the bill passes through the House.
My lords, it is a pleasure to hear someone who's only been once to Canada, or first generation, because I came deliberately because I suppose my family are now in the 5th generation of visitors to Canada. And in a way, it was my great-grandfather who really started off the whole debate of which we are concerned today, because it was in his time as Governor-General that the motion was put that Canada should become a nation, and how it was rejected was one of the elements, the most exciting and inflammatory elements of Canada itself. For as he left the Parliament House, he was stoned and nearly killed, and the Parliament House was burned down. And yet, as a result of 6 years of patience that followed, he was able to bring all people in Canada to an understanding of what responsibility meant in parliamentary government. And it is this, I think, that has run through the whole tenor of the debate today. I've heard all your lordships' speeches referring to perhaps the Confederation of 67 as the most important part, but indeed the beginnings of Canada had struck more deeply, I believe, than even that in the years before. And it was a hard beginning, and it is this, I think, that is well worthwhile remembering in the course of saying, as it is perhaps, a farewell. It is a farewell full of an immense pride. And I think to hear 2 maiden speeches of Canadians so redolent of the excitement and fulfillment of their country at this time was part of the excitement of this debate. But, my lords, my great-grandfather did not only, as it were, spend time in Canada, he also brought up his family. And so it was that my grandfather is in fact also Canadian-born, along with many other of the noble lords who were referring to these things earlier in the debate. And he was perhaps the first Canadian-born member of your lordship's house. And I think quite certainly he was the first Canadian-born member of a British cabinet. And indeed, in 1907, he moved a most important amendment to the North America Act. And that amendment had two forces, as it were, both of which, I think, touch upon so much that has been spoken of here this afternoon. The first was that there was an imperial sum of money. There was £500,000, a very large figure in those days, to be spent on the improvement of the trading facilities on both shores of Canada. It was to improve the transportation of goods between east and west. And the other was to ensure that in the provinces of Canada there was proper administration of the funds which the federal government would raise on behalf of the people in the provinces. And when he was pressed in your lordship's house at that time, and I bring his notes with me so that I would not make any mistake, he said of the first, about the imperial government's contribution, that no doubt trade would follow this facility. But of the other, of the contribution to be given by the federal government to the provincial governments, and to the manner in which the provincial governments would look after the provinces, there he said something else. He said, I feel that this embodies the whole sentiment of union. And it was this union, and it always must be, considered in Canada the union of province and federal government. Canada being so large, Canada being, as it were, governed perhaps more by the railway and then by air transport, and no doubt perhaps also by telephone. These things which have brought unity to so vast a country, and these things that have made in that country so many diverse, but at the same time most agreeable and lovable people. It is to all the people of Canada that the strength of what this bill must mean in its passing is of such importance. It cannot at all be easy for a country to feel that it is at one moment a country and then not so. But the passage of this bill will put an end to that. And I believe also that it will bring out of Canada, perhaps just as it did right at the very start, this passionate feeling for responsibility within their own country. They were the first of all the great dominions, and then the self-governing dominions, to show what responsibility meant in parliamentary terms. And it is this that is so important in our reflections, for it is this that Canada created of itself, perhaps in the most bitter way, but after calm and quiet reflection, they made of their country, with all its difficulties in width and scope and diversity of peoples, what has been spoken of this afternoon, a country that can produce something in terms of human relationships, perhaps greater than any other of the free lands in the world today. They have produced for us in this bill something of greatness and something still with a test before it. What more can you ask of any nation but to turn to them and say, go on with your spirit of responsibility, with those tests of authority, and of kindness and understanding to all the peoples in your land, and know that we all wish you the very greatest of success. But, my lords, for myself personally, and I believe this most deeply, that though this bill, and I know that it will pass, I am certain that it will pass and become a part of the nation of Canada. But for me, there can never pass, nor for any member of my family, that feeling that we have something in another land for which we have taken part both now and in past times, of which to be proud, for we have seen a country grow up and be strong in the greatest and most profound responsibility of our time. And my lords, I wish and hope that this bill may pass with all your blessings.
My lords, the bill which we are discussing today is both very important and highly unusual. Because, my lords, as I see it, it is the first time that we have an old Commonwealth country virtually being given at least a very large degree of independence. My lords, I must confess that I have never myself been to Canada, but I have been to a number of other parts of the Commonwealth, and I am a very dedicated member of the Commonwealth Parliamentary Association, which does bring me in touch with a number of Canadians. My lords, I do know New Zealand quite well, and there are certain affinities, particularly bearing out the problems of Clause 35 with New Zealand, even though they are not necessarily comparable like with like. But the Maori population in New Zealand has, over the years, integrated, on the whole, very well with the rest of the population, even though there are today more problems than there were, say, 50 years or so ago. My lords, as has been said, there are in all countries problems which minority groups face, and the great test is as to how these can be solved. And, my lords, the great test of this bill will be, when it becomes law, as to whether the very high ethical standards for which the Commonwealth is renowned can be maintained and indeed improved. There is also the question, as I see it, my lords, as to how far Her Majesty's government can intervene in these matters. Now, on the very vexed question of the Aboriginal rights, and it is, of course, absolutely proper and indeed central to the bill that this matter should have been raised both in another place and in your lordship's house. It's Clause 37 of the bill seems to me to at least provide some degree of a solution, where it says in subparagraph 1, a constitutional conference composed of the Prime Minister of Canada and the First Ministers of the provinces shall be convened by the Prime Minister of Canada within 1 year after this bill comes into force. My lords, what is important, and what I hope the government, this government, will take on board, possibly in consultation with the Canadian government, is that this conference will be represented by a very wide spectrum of Canadian life. In other words, my lords, that the Aboriginal persons will be represented at this conference, because it is clear, as I see it, that much of the significance of this bill will come to light after it becomes law, and when Canada, so to speak, takes over. So I do think and hope that Clause 37 will be paid attention to very closely. My lords, my noble friend Lord Elgin and King Carrington has, I think, summed up the feelings of not only this House but this country as a whole, with his own very strong family connections with Canada, backed up by the two very notable maiden speeches which we have heard during the course of this debate. My lords, I think everyone will hope that as a result of this bill, the links with ourselves and Canada, and I mean all parts of Canada, will be forged even more strongly, because it will enable much wider terms of discussion to take place. It will be clear, I think, that the Canadian Parliament and our own will need to consult even more closely than they do now. It is quite clear that since this is an unusual bill, problems will emerge. But, my lords, despite the problems which this bill generates, and any transfer of any constitution must inevitably bring problems, I believe that this bill will strengthen the links between our great countries. The sooner it gets on the statute book, the better. And when it has got to the statute book, then I believe is the time for some really close negotiations and discussions. My lords, I wish the bill well.
My lords, I think that I ought to immediately to declare perhaps an oblique interest in wanting a successful passage for this bill before your lordship's House, to give effect to a request by the Senate and the House of Commons of Canada. I've travelled to Canada on a number of occasions. In 1968, 14 years ago, I was in New Brunswick at the fall convention of the University of New Brunswick when honorary doctors of laws degrees were conferred on the then Minister of Justice, the Honourable John Turner, on Mr. Justice Bora Laskin, then of the Ontario Supreme Court, and Dr. A.F. Smith of the University of Michigan, USA, and R.W. Brigginshaw, then a General Secretary of the Society of Graphical and Allied Trades in the United Kingdom. At the Spring Convention of the same university that year, honorary degrees of Doctors of Laws had been conferred on the noble and learned Lord Goodman and upon the Right Honourable Michael Foote. Noble lords might ask what such a diverse number of recipients had greatly in common at that time. I would not attempt a precise detail, but I am sure of a real common factor, and it would have been their great admiration for the united strength of Canada and of its vast activities and potentialities economically and diplomatically on a world front. This bill before us on a second reading does not need, my lords like to hear, does not need long speeches in its support. It is a sum of so many things, and it speaks for itself. Study of the bill and matters before us will, I'm sure, guarantee us. Let me say, its presentation and passage in this Parliament could so easily have been bungled, with quite dire consequences in my view. Whereas on the contrary, and it would be churlish of any supporter of this bill in your Lordship's House at this time not to compliment the government of the day on the successful work in our parliaments in bringing this bill so far. For my part, I'm satisfied in commending the passing of this bill in second reading, to use the words from my speech made last year in Edmonton, Alberta, by an eminent Canadian, the Honourable M. McGuigan, Secretary of State for External Affairs. And he said, amongst other things, Canada has long since won its sovereignty and independence in the two world wars and through a process of constitutional development which in some ways at least serves a model for the world. Both Canada and Britain, both for Canada and Britain, it would be a tragedy to mar the shared history of the constitutional developments at the very end of the process. My lords, I cannot see us solving a problem in Britain or Canada by making it a problem between Britain and Canada. We cannot patriate the problem without patriating a solution. And this is the essence of the bill as I see it that's before you today. I do not discount, my lords, the interests of the Indian peoples. When I say we then let the responsibilities for the measures contained in this bill belong where it must in the end, with the government and Parliament of Canada. Finally, I only wish to make one general reference to the content of the bill before this House. To ask noble lords to look through the bill itself from pages which cover the, merely to peruse with me, the Constitution Act 1982, modernization of the Constitution, and to traverse quickly, with our mind's eye, the procession of our history and that of Canada, marked out for us in the headings of the changes in column 1 of each of the pages 30 to 37, in the English and French languages. Let us fulfill, my lords, our part in this graphic procession of history, to which I draw your lordship's final attention, and with good grace, pass this bill as requested.
My lords, first of all, I'd like to, as with others, congratulate the maiden speakers on their excellent speeches and say that one reason why I have a very strong affection for Canada is that I had a few years of schooling in Canada in the province of Ontario. The concern and interest for us in this House is that we may do our part in an honourable way
and with some idea of the unique and the complex subject matter of this Canada Bill. Easy it is for some when it comes to the, shall we say, the more legal side. There's a lot more behind this bill than one realizes at first sight. The more material that one went through brought this factor before one. Can our my honourable friend, the Foreign Secretary, assure us that the assurances are positive to all, including the Indians? They do not seem to have come off very well from the treaties signed with them. They do not want to be assimilated as a white person, but to develop in their own customs and culture as a Canadian citizen. And they would and are ready to support a constitution like any others of the peoples in Canada. I will quote from a few voices of concern from several received. In fact, some of these may be satisfied now, since the 8 provinces which first of all were in disagreement have come to agreement. But I think these few here possibly still aren't all that happy, because this has come only recently. From Ruth Gorman, the Calgary Herald: "You may think that past laws will still guarantee your property rights. That's wrong. Built into this Constitution is a section which makes any law inconsistent with this Charter, inoperative and of no effect." The former Justice slams Charter, the Calgary Herald, February the 12th, 1982. Despite the lengthy enumeration of fundamental, legal and non-discriminatory rights in the Charter, Markland said his personal feeling is that it does not particularly add anything to the position of the individual citizen. He pointed to Russia, which is what he described as one of the broadest charters of civil rights in the world, and remarked, "We all know how well that works out." Markland explained that Britain has no written charter of rights, rather a tradition of fair play and regard for the rights of others. And there is James Richardson, one Canada for all Canadians, and another one, "Can bilingualism of Canada bring about one nation?" I hope, and will end by expressing the hope, that the Indians, all the different Indian tribes or groups, nations, will be receiving a just settlement. And may I quote the first few lines of what's called a Declaration of the First Nations, the Joint Council of the National Indian Brotherhood, November the 18th, 1981. "We, the original peoples of this land, know the Creator put us here. The Creator gave us laws that govern all our relationships to live in harmony with nature and mankind. The laws of the Creator defined our rights and responsibilities. The Creator gave us our spiritual beliefs, our languages, our culture, and a place on Mother Earth, which provided us with all our needs. We have maintained our freedom, our languages, and our traditions from time immemorial. We continue to exercise the rights and fulfill the responsibilities and obligations given to us by the Creator for the land upon which we were placed. The Creator has given us the right to govern ourselves and the right to self-determination. The rights and responsibilities given to us by the Creator cannot be altered or taken away by any other nation. why has it been decided to wait until after this bill has gone through and been returned to Canada to have talks within a year with the Aboriginal peoples? Surely they could have been brought into confidence, shall we say, before that time. The documents of the Indian governments of Saskatchewan, Federation of Saskatchewan Indians, and others put some doubts in one's minds. Also, another one, the First Nations States of Canada and United Kingdom. My Lords, I too would like to end by wishing Canada well and hoping too that Quebec will be able to find a place and come into agreement with the other provinces, and hoping and praying that the minority groups will be able to find a place, and it will be seen that we Europeans are not just trying to prevent them from being in poverty, not just trying to prevent them from being alcoholics, and so on and so forth, but that we are really being able to help them be a people, to be them, to be their culture, their ways, their tradition, but as part of Canada with all the rest of the Canadians. And so, God bless Canada, and I naturally agree that it is only right and proper that we agree to this bill, but I'm sure and I hope that any little concerns which have been expressed, I believe the Canadians will hearken to them and try to respond. And I do hope that the noble Lord Stewart does not press his motion.
My Lords, in opening, I would like to say how I delighted in the rich Canadian tones of Lord Shaughnessy in his maiden speech. In fact, he made me feel less alone than I feel in your Lordship's house, because I believed that I was the only person who bore two titular towns, neither of which were in the United Kingdom. And he similarly bears two titular towns, neither of which are in the United Kingdom, one of which is in Canada, and one of which is in the Republic of Ireland. And this I learnt from him, and he certainly delighted me with what he had to say. My Lords, I think it would be churlish if I were not to make mention, to start with, to my deep gratitude to those many parties and people who have kept me informed on this very complicated and extremely important subject over more than 2 years. And I've learnt a very, very great deal from these very good people. And in particular, one thing I have learnt is that the government of Quebec in London can boast the best table in London, and that the government of Canada in London can boast the prettiest hostess. My Lords, there could be no one who would disagree with the intention of Parliament to transfer the legislative authority, the legislative power to amend the Constitution of Canada from the United Kingdom to Canada. It is patently absurd that the responsibility should reside other than in Canada. However, the dilemma for the Parliament of the United Kingdom is that it is being asked not only to transfer the legislative responsibility to amend the Constitution of Canada, but to enact for Canada the supreme law of Canada, to enact that law which would make any subsequent statute enacted in Canada, which is inconsistent with that supreme law, of no force and effect. And as such, my lords, it is of vital importance. The constant and consistent stance taken by the Government of Canada has been that it is not the business of the Government of the United Kingdom to in any way hinder the request of the Canadian Parliament. I would entirely agree with that. But however, my lords, what I do find monstrous, and it is typical of all government, is that they extend this principle by suggesting that it is not the business of Parliament. My lords, it manifestly is the business of Parliament, of this Parliament and of the Parliament of Canada. For this request and consent comes from the Parliament of Canada to Her Majesty the Queen in Parliament of the United Kingdom as assembled. And I believe it is our manifest duty to consider those aspects which concern us. My lords, I believe that very great credit should be paid to those few members of the House of Commons of Canada and those few members of another place, and indeed to the members of your Lordship's House, who've had the courage to voice the reality that lies behind this bill. Namely, that this bill paid legislative lip service to a noble and long overdue attempt to afford the First Nations of Canada the protection of the courts, and in the long run, the protections of the Supreme Court of Canada. In addition, my lord, this bill erodes the ancient protection afforded to the Indian peoples by the sovereign in right of Canada through the person of the Governor-General of Canada. My lords, these are no mere debating points or personal points of views. These are facts which are made manifest not only by careful consideration of the bill itself, but by consideration and examination of the history of the bill and of the relationship between the executive and the courts of Canada and the Indian people. The Parliament of the United Kingdom is being asked to send the North American Indians of Canada naked into their future with no, or at best, little remedy in the courts of Canada against any determined government or legislature in the future. And that is the legislature of the federal Parliament and the legislature of the provincial parliaments. The bill provides the means whereby the executive and parliaments of Canada in the future could fulfill their oft-stated policy of extinguishment of native title without proper negotiation and with those most affected and with no guarantee of proper compensation. My lords, for those who have doubts as to what this policy is, have doubts of this intention, may I be allowed to quote from a document which was issued by the Department of Indian Affairs a short time ago, is November of 1980. And I must read this because this is vital. And the very language itself shows one of where the many interests in Canada are seeking the final solution of the Indian question. And I quote, while the 1973 policy did not mean government recognition that natives own the land or recognition of native title in legal terms, it was made clear the settlement would only take place in return for whatever interest they might have in land. In accepting this position, the government insisted on a clear and unequivocal legislative extinguishment of all traditional native rights, titles, and interests, whatever they might be, so that the claim in question could never be raised again, and to remove every possible cloud upon the Crown's title that might inhibit the exercise of that title. My lords, equally worrying was one of the conclusions arrived at in this document. It was, and I quote, it's very short, greater emphasis should be placed on the concept of exchange of traditional interests for conferral of specific rights and benefits, de-emphasizing the term extinguishment. My lords, look to the language and you will find the truth. For the use of the word extinguishment presumes the existence of title. How then, your lordships might very understandably ask, how then could my noble friend Lord Carrington and many other noble lords contend that this bill, and I quote his words, specifically recognised the rights of indigenous people? My lords, I'm reminded of the story of the reading of a will by a solicitor, which went something like this. And to my cousin Louis, who always said that I would never recognise him in my will, hello, Louis. And it's by reading section 25, it becomes immediately clear that this is solely one of interpretation and construction. But this is the point which is raised so beautifully, if I may say so, by the noble and learned Lord Scarman, and indeed by my noble friend Lord Renton. And it is not a clause of substance. Moreover, it is only a clause of interpretation and construction as regards the Charter of Rights, and not as regards the bill as a whole. I can only hope that the courts in Canada, and it is quite wrong presumption of me to presume this, but the courts in Canada will have the wisdom and understanding that is there in the noble and learned Lord Scarman, and do interpret the bill as noble and learned Lord Scarman suggested. But the tragedy is that it can be looked at either way. And indeed, the parliamentary secretary to the Minister of Justice of Canada, I believe, got it absolutely right when he recognised that Clause 25 does not recognise and affirm the existence of Indigenous rights. When this clause was discussed in the Canadian House of Commons, he said, and I quote, "In other words, if they have rights, then they will not be extinguished by the Constitution." Furthermore, noble lords might well believe that Clause 35 does the job.
I wonder if my noble, I very reluctant to interrupt. I think it's the first time a speech in this debate has been interrupted, but I think that I must assure my noble friend Lord Morris that Clause 25 is really a safeguard because it enjoins upon the courts that when construing other clauses of that schedule, they may not, to use the words that are here, abrogate or derogate from any Aboriginal treaty or other rights or freedoms. And that is an unusual provision and one which we should welcome because I really do believe it's a safeguard.
Lords, I do indeed welcome this clause, of course, and I do take the point that the noble Lord has raised, but with the greatest respect to him, and I'm really jumping in with both feet, arguing with a lawyer, because I'm not one myself, is that my understanding of this clause is that it is only one of construction as bears on the Charter of Rights and not the whole of the schedule, not the whole of Schedule B. And furthermore, if the intention was real that these rights be recognised, why was it not written in the positive and instead of the negative within the Bill of Rights? And why were the words, as you indeed, indeed my noble friend Lord Renton himself raised in his, if I may say so, excellent speech, that the key words are construed, and construed so as not to abrogate or derogate from. And I would have loved to have seen this intent written in a positive way, affirming the particular rights. But these are fundamentally committee points, and I'm sure that they will be developed, and hope they will be developed in committee. My Lords, the reason why Clause 35 in a sentence, I believe, is not strong enough, is that is the inclusion of the word existing is takes away from the original clause very, very strongly indeed. And I'm not going to go into it in detail because it is fundamentally a committee point. But one has got to read 35 in connection with section 37, which sets up the conference, which is deliberately designed to identify and define those existing rights. Not the rights in the past, but the rights that will be defined on the 37, which are to be included in the Constitution. And my Lord, 37 itself begs these questions. Who writes the agenda of the conference? How long will it last? What does the phrase, the Prime Minister of Canada shall invite representatives of the peoples to participate in discussions mean? Will they be mere observers? Will they be part of the decision-making process? Will they be allowed to be represented by council? And all these questions cause great concern, and I do hope, as I've said before, they will be developed properly and fully in committee. My Lords, much has been said that even to question the merits of the Canada Bill is embarrassing, is tactless, is indelicate. My Lords, where natural justice, where freedom of the individual is concerned, I do not believe that one should concern oneself with one's personal feelings. Modern history has many terrible examples of the insidious effects of silence. If I may say so, I think the official policy of the Liberal Party has all the charm of the policy of Pontius Pilate. My Lords, we cannot and should not wash our hands of our real fears where freedom of the individual is concerned.
Could I ask the noble lord, is he at this stage suggesting that we're going to be asked to amend this bill? Doesn't he realise that that is not possible?
My Lords, the noble Lord Byers has inferred something which I neither stated nor implied. And I think it was really very remote from what I said. What I was suggesting was to wash one's hands, to pretend these problems don't exist, I think is very disturbing. And if one had read the proceedings in another place, which were admirable, one would have, I think, would have got the message really very clearly indeed. Our only duty is to raise these points and hope that they reach the right hearts. My Lords, I know that history will undoubtedly place the noble and learned Lord Denning among the greatest of this or any other century's judges, when he ruled that, and I quote, no parliament should do anything to lessen the worth of these guarantees. He was, of course, referring to the Treaty of 1763, the Royal Proclamation of 1763. His words must command immense respect. I find it deeply disturbing that this Parliament is being asked to do just that. My Lords, in 1967, when Canada celebrated its 100 years, Chief Dan George, a hereditary chief of the Salish tribe, spoke these words: "How long have I known you in Canada? 100 years? Yes, 100 years. And many, many years more. And today, when you celebrate your 100 years, O Canada, I am sad for all the Indian people throughout the land. For I have known you when your forests were mine, when you gave me my meat and my clothing. I have known you in your streams and rivers, where your fish flashed and danced in the sun, where the waters said, come and eat of my abundance. I have known you in the freedom of your winds, and my spirit, like the winds, once roamed your good lands. But in the long 100 years since the white man came, I've seen my freedom disappear like the salmon going mysteriously out to sea. The white man's strange customs, which I could not understand, pressed down upon me until I could no longer breathe. When I fought to protect my land and my home, I was called a savage. When I neither understood nor welcomed this way of life, I was called lazy. When I tried to rule my people, I was stripped of my authority." My Lords, it is this that we are talking about. And it is this what the noble and learned Lord Scarman was talking about. My Lords, it encapsulates the whole of the fears that were expressed in another place. I can only hope and pray that the free press in Canada, that the independent bench and bar of Canada, that the Parliament and governments of Canada keep good faith with the people of Canada and never mar in the future the conscience of their people. I hope and pray that the most liberal interpretation is placed on these sections designed to protect, that then and then only can Canada play confidently the role in the World Council which Canada is so eminently, and has proven itself to be so eminently suitable.
My Lords, the historic importance of the Canada Bill, which we've been discussing all day, is reflected in the long list of distinguished speakers who took part in the debate, which was adorned by two admirable maiden speeches from the Lord Shaughnessy and the Lord Rodney. My Lords, this bill has raised considerable emotions, both in Canada and in this country and in both houses of Parliament. All of us regard the friendship between the peoples of Canada and of this country as of the most precious value to us. Most of us have personal links there. I've had the pleasure of being there on several occasions, legal, political, and personal. I remember particularly representing this country at the celebrations of the centenary of the distinguished Supreme Court of Canada. My last visit to Canada, however, was of rather a different nature. It was to preside in Vancouver over a fine Gamanva Gani, the singing festival of the Welsh societies of Canada and the United States. We all sang mightily, as good as the singing in Cardiff Arms Park when Wales is winning. My Lords, what we are doing in this bill, and what my noble friend Lord Stewart of Fulham in his admirable opening speech made clear, is to respond affirmatively to the consent and request of the Senate and the House of Commons of Canada to enact their Constitution Act and to terminate the power of the British Parliament to legislate for Canada. The survival of that power in the British Parliament is a remarkable anomaly. We have not wished it, and it survived because the Canadians themselves were unable to agree on a formula for the future amendment of their constitution. Now, with the important exceptions of Quebec, and in terms of the amount of attention that's been paid to it of the Aboriginal peoples, with those exceptions, a significant measure of consensus has been arrived at in Canada in support of the proposals in the bill. The government wants it. 9 out of 10 of Canada's provinces have become parties to it. The Canadian House of Commons and Senate have approved of the package with large majority, and the Supreme Court of Canada has ruled favorably on all the crucial issues before they were debated at Westminster. But, my Lords, that course of events in my submission has not eliminated the legislative duties of Parliament. And I was delighted to hear the noble and learned Lord Scarman emphasizing that, and whatever the fate of these proceedings tonight, we shall certainly return to the battle at the committee and report stage. My Lords, the great value of the motion in the name of my noble friend has been that it has provided a crystallizing, a superb means of enabling the House to concentrate on what has caused most anxiety and concern, namely the question whether the grievances of the Indian peoples are adequately resolved by the terms of the bill. Those grievances have been described with great eloquence in the course of this debate. It is not merely the fact of Indian alienation and poverty, which is not in dispute. It is not merely a question of their lack or inadequacy of property and land rights, but perhaps in some ways equally important, the continuing threat to their own unique and characteristic culture, as several noble lords have indicated in their speeches. My lords, the aim of the motion that we put down was by way of help rather than advice. And although I agree with what advice the noble and learned Lord Diplock gave on the legal and constitutional matters, and indeed I would be a very brave man to disagree with him, I do not agree with his censure of the motion in that it purported to give advice to the government of Canada, and that he described as something horribly unconstitutional. Well, the terms of the motion have been indeed criticized by some of my noble friends as being too complimentary and congratulatory of the Canadian government. The terms of the motion are that this House, aware of the anxieties that have been expressed about the Canada Bill, now before the House by representatives of the Aboriginal Peoples of Canada, and there's absolutely no doubt about that, is confident that the Government of Canada, in consultation with representatives of the original peoples, will use the provisions of the bill to promote their welfare. Perhaps the fault of the motion was it was too innocuous and that it did not suffer from what has been dismissed by one noble lord as a piece of paternalistic admonition, I think was the word the great historian used. My lords, we in our motion have sought and I think enabled the House to concentrate its mind on the necessity for the protection of the minority peoples in Canada. My lords, as has been said by my noble friend Lord Gifford and others, the protection of minorities has acquired a new and important significance in the contemporary world. The experience of Nazism and fascism and the suppression of minorities, and indeed of individuals, which was part of their regime, led to a determination of the post-war world to take whatever steps could be taken to avoid a repetition of that course of events. In the individual field, we changed the position of the individual from being a mere subject of from being a mere subject of compassion to being an object of rights. And so now the eyes of the world will be upon Canada to see how they deal with their minorities in the months and years that are to come. My lords, I will not recapitulate at this point of time all the matters of concern that have been raised, apart from the basic fact of the way in which the peoples, the Aboriginal peoples, have been dealt with by the white man. It was very interesting that the noble Lord Shaughnessy, with great restraint, said Canada's record in dealing with native peoples is not without blemish. It's true that he added, but it is better than most.
In order to back up the point that he was making, it was extremely interesting to me to learn that in 1867, when the British North America Act was passed, the word Indian in neither house of the British Parliament was even mentioned once. It's very interesting that today, and in the proceedings in another place, the term Indian has been used over and over again.
Well, indeed, and this is one of the values of the debate in both houses, if I may say so, of Parliament. it has brought their existence, their needs and their grievances into the forefront. My Lords, the two specific matters which will be referred to, I've no doubt, at the later stages, have been mentioned in the admirable speech we've just heard from the noble Lord Morris, if you'll allow me to say so. That is, first of all, in regard to the important clause 35 of the bill of the introduction of the word existing, and we shall undoubtedly return to that later. But there is another matter which, in my view, may well be of more significance than that, and that is the provisions of section or clause 37 of the bill. My Lords, that, as your Lordships will see, provides for a constitutional conference composed of the Prime Minister of Canada and the First Ministers of the provinces, shall be convened by the Prime Minister of Canada within 1 year after this part comes into force. Then, the conference convened under subsection 1 shall have included in its agenda an item respecting constitutional matters that directly affect the original peoples of Canada, including the identification and definition of the rights of those peoples to be included in the Constitution of Canada, and the Prime Minister shall invite representatives of those peoples to participate in discussions on that item. Then it goes on to say the Prime Minister shall invite elected representatives of diverse territories which are not immediately relevant to the conference. Now, my Lords, that conference is obviously going to be of great importance, and we do await a positive commitment by the Canadian government that those representatives of the Aboriginal peoples who will have a seat at the conference when matters affecting them are discussed, and we venture to express the hope that the federal government will be able to declare that the Aboriginal peoples will be involved as profoundly as the provisional governments in the task of identifying the rights of the Aboriginal peoples. And we shall await the information that will emerge from the Canadian government upon those matters with impatience. Now, my Lords, we have had a long and an impressive debate, and the comfort it will give to the Canadian peoples and government will, I hope, be considerable. The unanimity of admiration for what Canada has been achieved has been expressed from all parts of the House. I hope that what has happened here and the publicity we have given to the grievances of the Aborigines and what we expect to emerge and hope to see emerging hereafter, those will have reached the world political map. But, my Lords, in view of the lateness of this hour and the desire to avoid an inadequate turnout, if that's the right word, of members of your Lordship's House in a division, my noble friend, Lord Stewart, and I and the rest of us have come to the view that although our motion remains on the order paper, it will not be moved, and the House will not be invited to divide upon it.
My Lords, I have listened, I must say, with the greatest attention to this most interesting, not to say historic debate, not least to the speeches of our maiden speakers today, my noble friend Lord Rodney and the noble Lord Shaughnessy. It is clear that the views expressed reflect deeply held concerns about aspects of this bill. And as my noble friend Lord Carrington said in his opening speech, it is a most unusual bill. Indeed, it is unique. We are the final executors of a responsibility which has for many years been out of its time. As a result of our deliberations, the full authority for the Constitution of Canada will be transferred to its rightful place. My Lords, by tradition, the task of the Minister winding up a debate is to respond on behalf of the Government to the questions raised, but your Lordships will be aware of the constraints upon me in that role tonight. The Government's position is that the contents of Schedule B to the Bill, which will have application only in Canada and not in the United Kingdom, are a matter for the various governments and legislatures of Canada to decide, and not something on which the British government should comment or offer interpretation. This attitude inevitably restricts what I am able to say in response to the matters which have been raised, but I will attempt to give as full an answer as I can. The main concerns expressed during the debate have related to the position of the Aboriginal peoples and to Quebec. We are clear in our view that questions concerning the Indian and other Indigenous peoples of Canada are Canadian internal matters and not matters in which the British Parliament any longer have a responsibility. It has consistently been the view of the Government that any treaty or other obligations concerning Indian interests, insofar as they still subsisted, became the responsibility of the Government of Canada with the attainment of independence, at the latest with the Statute of Westminster 1931, and that it is to the Government of Canada that the Indians must look for solutions to their problems. This view was accepted by the Select Committee on Foreign Affairs of Another Place in their first report presented at the beginning of 1981 and in their third report of December of that year. In paragraph 9 of that third report, the committee state, "The fact is that Indian rights and affairs have been an exclusive responsibility of the Canadian Government and Parliament for generations. For at least 50 years, the United Kingdom Government and Parliament have lacked even residual authority to intervene in relation to those rights or affairs." The question was also considered recently by the courts here, from whom the Indian Association of Alberta had sought a declaration that the position adopted by the British government was wrong in law. Your Lordships will recall that on the 28th of January, the Court of Appeal unanimously rejected the Alberta Indians' application and gave it as their opinion that any obligations of the Crown to the Indians of Canada are now owed by the Crown in right of Canada and not by the Crown in right of the United Kingdom. In his judgment, the noble and learned Lord Denning said, and I quote here, "The obligations under the proclamation and the treaties are obligations of the Crown in respect of Canada. They are not obligations of the Crown in respect of the United Kingdom. It is therefore not possible for the Indian peoples to bring an action in this country to enforce these obligations. Their only recourse is in the courts of Canada." On the 11th of March, the Appeal Committee of your Lordship's House refused the Alberta Indians leave to appeal to the House of Lords, and the noble and learned Lord Diplock, read verbatim their Lordship's decision on that occasion. The Government, therefore, are reinforced in their view that any dissatisfaction expressed by the Indian peoples with the provisions of the Bill can properly be pursued by them only with the Government of Canada and in the courts of Canada. Many of your Lordships, I think, accept that this is the constitutional position, but have nevertheless felt obliged to put on record their concern at various aspects of the Indian policy of the Canadian Government and their opinions on the welfare of the Indigenous people of Canada. Her Majesty's Government in the United Kingdom have taken note of these views, and we know that they will be noted in Canada. Your Lordships will be aware, though, that it is this Government's view that it is not for us to judge the rights and wrongs of the situation of the Indian peoples and the implications of Canadian law of the proposals of this bill. I noted that one or two noble lords suggested that we should not proceed further with this bill until all the Indian court actions in this country had been completed. And indeed, the Government decided to await the outcome of the appeal by the Indian Association of Alberta to the Court of Appeal before we did so proceed. The Government have, of course, considered very carefully all the issues raised by the respective plaintiffs in the two other cases touching on the Canadian Constitution that are now pending in their preliminary stages before the courts in this country, having regard, among other things, to the nature of these issues, to the way in which they have been presented to the courts, and to what courts, both in this country and in Canada, and what they have already said on this matter, the government has decided that it is right for us to proceed with this bill without waiting for these cases or any others which may be instituted to be disposed of by the courts. To do otherwise, my lords, could lead to an indefinite delay. The noble Lord Brockway, and I think one other noble lord, asked if the government would make representations to the Canadian government to impress upon them the views held by some of your lordships about the position of the Indians and other Aboriginal peoples. While the government fully respects the right of noble lords to express their views on subjects about which they feel strongly, I do not think it would be right for the government to put these views to the Canadians, who are in any event, as I have said, well aware of them. Whatever our private views, it is not a British responsibility. Canadians have acknowledged that it is their responsibility. It would be an affront to suggest that they will not take that responsibility seriously. One or two noble lords suggested that the government should not proceed with this bill without the consent of Quebec. The fact that these proposals do not have the support of this great province, which is a founder member of the Federation, is a matter for regret. The government believe, however, that your lordship should be guided by the views taken by the authorities in Canada on the question. The Supreme Court of Canada concluded that as a matter of convention, at least a substantial measure of provincial support was required, but declined to express a view as to how many provinces or name any whose support was essential. Presumably, if the Supreme Court of Canada had thought that unanimous support was required, they would have said so. The overwhelming vote in the Canadian House of Commons on the 2nd of December in favour of these proposals included 68, no less, of the 75 federal members of Parliament from Quebec. The resolution was later passed in the Senate by 59 votes to 33. The Foreign Affairs Committee of another place, to which I referred just now, which is, of course, an all-party body, in its third report said, and I quote again, "We consider that it would be proper for the United Kingdom Parliament to enact the proposals, notwithstanding that they will directly affect the powers of the Canadian provinces and are dissented from by one of those provinces, Quebec. We arrive at this view on constitutional grounds. It is regrettable that so large and distinctive a province as Quebec, a founding province, dissents from the present proposals. That dissent may have significance for the welfare of Canada. However, that is a matter of political judgment and not something which should concern the United Kingdom Government and Parliament in dealing with a constitutionally proper request from an independent and sovereign country. The Premier of Quebec, Mr. Levesque, has made known to the British government his hope that we would not proceed with the Canada Bill until the Quebec Court of Appeal had ruled on the question of whether or not Quebec historically has the right of veto over constitutional changes with which it does not agree. The government believes that given the terms of the judgment of the Supreme Court of Canada on the 28th of September and the fact that the Canadian Parliament then formally requested action by the British Parliament, the existence of further legal proceedings in Canada of the kind referred to is entirely a Canadian matter. Indeed, in these circumstances, I hope your lordships will agree that it would not be appropriate for the government to suspend action on the Canada Bill. My lords, can I deal with now one or two of the other points that have been raised? I would not accept the suggestion made by one or two noble lords, including, I think, the Right Reverend Prelate, the Bishop of Chelmsford, that the United Kingdom would be in breach of their obligations under the International Covenant on Civil and Political Rights if this bill were enacted in its present form. In the opinion of the government, our responsibility is to enact the legislation as requested by the Canadian Parliament. The question of the compatibility of that legislation with Canadian obligations in international law and its interpretation and application in conformity with Canada's international obligations are matters for Canada. Furthermore, the International Covenant incorporates provision for ensuring its implementation, In the case of Canada, it is possible for individual allegations of breaches of particular articles of the Covenant to be brought before the United Nations Commission on Human Rights. If, therefore, any of the Aboriginal people believe that rights prescribed in the Covenant are being violated, a remedy is open to them. The noble Lord Brockway also referred to the shortened timetable, and I think some other noble lords criticised the timetable as well, suggesting that it was perhaps too condensed for proper consideration to be given. I do acknowledge that many noble lords feel that the bill to be of such importance that they would not wish it to be rushed through without the benefit of the measure of attention that it deserves. But of course a number of noble lords did express a contrary view to that. But in planning the timetable, the government had in mind that we are dealing with a bill which is not a piece of domestic legislation, but has come before us in response to a request of the Senate and House of Commons of Canada, who passed it by substantial majorities in both houses, to which I referred earlier. The substance of the bill, that is Schedule B, has been the subject of extensive debate in Canada and will apply to that country, not in this. For this reason, our responsibility for it is limited. May I now just refer to the question of amendability of the bill, which the noble and learned Lord Elwyn-Jones raised, the noble and my noble friend Lord Morris, I think, raised rather obliquely, and indeed I think it was also implicit in the remarks of the noble Lord Gifford. The rule is, my lords, and this comes from, I understand, from the companion, the rule is that amendments must be relevant to the subject matter of the bill. This derives from the more general statement of the rule in regard to the relevance. In Standing Order 25, debate must be relevant to the question before the House. This bill is clearly confined, as indicated by its long title, to provisions which give effect to a request by the Senate and the House of Commons of Canada. The bill is therefore concerned solely with giving effect to that request. If it is altered in any material particular by any amendment, it would no longer be confined to giving effect to that request. My lords, I am advised that any amendment of any substance not tabled at the request of the Senate and the House of Commons of Canada would thus be irrelevant to the subject matter of the bill. I must say I very much hope that the House will accept this advice and that my noble friends and noble lords will desist from tabling amendments. But I emphasise that that is advice which has been received and is in no sense a ruling, certainly not from me.
Would the advice that the noble Lord the Minister has given apply not to amendments which seek to change the actual constitution in Schedule B, but which seek to delay the coming into operation of this bill until such guarantees that may be asked for in amendments are given?
My lords, my off-the-cuff reaction to that is that we have received a request from the people from the Government of Canada and that we should proceed with it forthwith, and that any amendment which sought to prevent that would therefore be out of keeping, at least with the spirit of the Standing Order. But I hesitate to offer a definitive ruling. I suggest that the noble Lord takes the matter up with the authorities of the House at an appropriate moment. My lords, in sum, we are here considering a request by the Federal Parliament of Canada. The government has consistently taken the view that we must leave it to Canadians to judge what is good for their country. It is, after all, an anomaly that we are in a position of debating the affairs of Canada at all. The essential purpose of the legislation is to remove that anomaly and let Canada manage its affairs unfettered by this restraint. I do not think there is any noble lord who questions that Canada is the right place for legislative authority over the Canadian Constitution. We must be careful in dealing with this bill not to put ourselves in the position that we are charged by Canadian people with being neo-colonialists. There is a big difference between this bill and the normal sort of independence bill passing through this House, and I think it is important that we remember the distinction. The bill before us is not concerned with independence. It is intended to remove an unnatural anomaly in the relations between two already independent sovereign states, the United Kingdom and Canada, which have enjoyed a relationship on the basis of equality for nigh on half a century. Throughout that period, Canada has been and remains an important friend and ally of this country. We have many historical associations and many ties of kinship, which I know are reflected by the membership of your Lordship's House. And I might, if I may say so, think that the ties that I have referred to have been very much reflected in the tone of the debate that we have had this evening, and also reflected, if I may say so, in the decision of the front bench opposite not to proceed with the motion which is on the order paper to follow this second reading. In more practical ways, our countries are linked not only in our joint membership of the Commonwealth, but in our joint participation in the family of Western industrialised states and in many other enterprises in international life. I confidently expect that when the constitutional question is settled, we shall look forward to a further deepening and strengthening of the friendship and cooperation between our two countries. I therefore welcome this opportunity to render to Canada that which is rightly hers.
The question is that this bill be now read a second time. As many as are of that opinion will say content. To the contrary, not content. The contents have it.
Not moved. I beg to move this House to now adjourn.
That this House to now adjourn.